It's his son. Right. Yeah, something. Okay. Can you have your single, you mean two, the same machine again?
Yeah, that was a good thing.
Did you put that on?
No, no.
You mean to show it to them?
I don't know if it tells the board, but I think, no, I don't know if it tells the board.
But you still pay. Make sure you tell them that. Give me the answer to that. Okay?
No, I really.
Alexis Matos, like 10:30. It's going on. Yeah. For
Recording YouTube, all right. Mr. Reyes, Jose, are you still in the courtroom?
Señor Reyes, José Reyes, ¿se encuentra todavía en la sala del tribunal?
Sí,
Yes.
The court has reviewed your application for counsel and it has been approved.
Este tribunal ha revisado su solicitud para que se le designe un abogado y ha sido aprobada.
gracias.
The court has
Okay,
appointed
thank
you an attorney today. Please make contact with her or call her today and schedule an appointment.
Este tribunal le ha designado una abogada el día de hoy. Por favor, contáctela o llámela y saque una cita con ella.
Esta información que tengo aquí, ¿verdad? La tarjeta.
Perdón, ¿puede
Sí.
repetir? The interpreter needs repetition. ¿Puede repetir?
This card. Ok, es que no decía en la tarjeta la información.
Oh, is this, am I going to receive a card with her information?
I just gave it to him.
Ya.
Se la acabo de dar. Yes,
Sí,
sí,
perfecto.
esa es.
Judge, you did say Esparza, correct?
Miss Elaine. Yes. Mr.
Pues
Reyes. Oh, I'm
es
sorry.
la señora Esparza, ¿verdad? Sí, es Elaine Esparza.
Sí.
Mr. Reyes' next court appearance is August 1st at 2 p.m.
Ok.
Señor Reyes, su siguiente comparecencia, es decir, la siguiente vez que se tiene que presentar en la corte es agosto 1 a las 2 de la tarde.
Ok.
Okay.
Ileana, does that work with you?
Yes,
Yeah.
Your Honor. It does.
Mr. Reyes, any bond will continue, conditions of your bond will continue. See you August 1st at 2 p.m.
Señor Reyes, cualquier condición que le hayan fijado en su libertad bajo fianza continúan vigente. Lo veo de regreso en agosto 1.
Gracias.
Thank you.
Thank you.
Gracias a usted.
Yo te digo algo.
Mr. Randall, are you ready, sir?
I think so, Judge. If we could have just a short break, I was able to speak with the county attorney. We were just outside discussing some of these cases. And if I could have maybe just 5 minutes, I wanted to talk to a couple of the people here because we might have some of the dispositions worked out, if that is okay with the court.
That'd be fine. Could I ask or inquire about 24 CR 175 Alexis Matos appearing by Zoom, and that's why we have Ileana here. Do you know what we'll do with that case?
Yes, Your Honor, we are going to ask for a continuance on that. We just got appointed and we haven't had an opportunity to review it. So if she could give us a call, I believe she has our information, and our receptionist and multiple people in our firm are fluent Spanish speakers, so she should have no issues communicating.
The interpreter wants to know, is Alexis Matos in the courtroom so I can interpret for her?
She's there by Zoom.
He's on Zoom.
Oh, okay, señora Matos, este es el caso. And the interpreter needs repetition of the case number is 24
CR 175.
Thank you.
Can you guys hear me?
Este es el número de caso en contra es el estado de Kansas en contra de Alexis Matos, es el número de caso 24 CR 175. Su señoría, el abogado defensor está pidiendo una postergación del caso porque hay ciertas cosas que necesito platicar con ella acerca de la posible disposición del caso. Si por favor puede llamar a mi oficina, usted ya tiene el teléfono y hay varias personas que hablan fluidamente el español en mi oficina.
Let's do it.
Can I speak?
Hmm?
Can you hear me?
We can hear you, but you're represented by Mr. Randall, so things should go through him.
He didn't understand. The phone was acting up. This is Alexis Lorenza. He's we're trying to see about her interpreting to tell you guys that he's trying to get a lawyer or see about to pay it.
He's already
Is
had
that
appointed
is
for,
that Alexis? I'm sorry, this is the interpreter. I'm confused. Who's this?
I'm
Do
his
I have
wife
to
and
interpret or not?
yes, ma'am, but he didn't understand you at first, and that's why I was trying to tell you because his phone was acting up that he couldn't understand you.
Ileana, could you,
Repeat. I'm
Sure.
going to repeat. Yes. Señor Alexis, yo lo tengo como Alexis Matos.
Liranza Mato.
¿Cuál es su apellido?
Alexi Liranza Mato.
Liranza. Liranza. Okay. This is Alexis Liranza Matos. El número de caso, este es Alexis Liranza Matos. Su número de caso es 24CR175. Su abogado ha dicho, está pidiéndole al juez que por favor postergue el caso para otra fecha porque desea hablar con usted acerca de una posible resolución del caso porque ha estado en comunicación con el fiscal a cargo del gobierno de Kansas, del estado de Kansas. Por favor, llame a su abogado en la oficina. Usted tiene ya el número telefónico de su abogado. Él tiene personal que habla fluidamente el español y desea platicar con usted acerca de esas posibles resoluciones del caso. Ahora, esta señora afroamericana que está al lado de usted está diciendo que usted desea contratar su propio abogado. ¿Es esto cierto? Por favor, dígaselo al juez.
Sí, quisiera contratar un abogado yo mismo personal. Me dé un término.
Yes. I would like to hire my own attorney.
Dice que van a tomar un acuerdo. ¿Puedo quedar con él? No, mira, ya me voy a quedarme con el mismo abogado, lo voy a llamar a él. A él lo voy a llamar.
Well, you know what? No, I won't hire my own attorney. I'm going to use this same attorney that was assigned to me, and I'm going to call him.
okay, that works. Mr. Randall, what date were we wanting to move to?
Ok, eso funciona. Señor Randall, ¿para qué fecha desea postergar este caso?
Your Honor, if we could continue this case to August 29th docket. And then Ileana, if you could let him know to call us, our number is 316-847-8847. And the person answering the phone will speak Spanish, so he'll have no issues communicating. And by the way, Ileana, hello, I remember you from Central County.
Yes. Hello, Mr. Señor Matos, este caso está siendo, se está pidiendo que sea postergado para el día 29 de agosto en la lista de causas de las 2 de la tarde. Su señoría, si por favor lo pueden continuar para esa fecha. Y el número telefónico al que debe llamar, señor Matos, si tiene con qué apuntar, es el 316-847. 316-847.
Ajá.
8847. Su abogado es la oficina de su abogado, el señor Randall, y usted puede, en ese teléfono le va a contestar una persona que habla perfectamente el español, por lo tanto no tendrá ningún problema.
Gracias.
Thank you.
Okay, August 29th at 10:30, Alexis, to make contact with Mr. Randall.
Señor Alexis, la próxima fecha es agosto 29, pero a las 10:30 de la mañana. Por favor, señor Matos, esté en contacto con su abogado.
Gracias.
Okay.
Thank you.
Thank you for your appearance.
Gracias por su comparecencia.
Gracias.
Mr. Randall, you need a brief recess for your cases at 10:30?
Yes, Your Honor. May I have 10 minutes, Your Honor?
Para que me hubieran atendido yo mismo.
May you have,
Ya se puede retirar, señor Liranza.
Gracias.
Your Honor, may I have 10 minutes?
10 minutes, certainly.
Pregúntale a la muchacha cuál es
We'll just take 10 minutes. Go ahead and
pregunta.
get off here. Thank you.
Una pregunta.
Thank you, Your Honor.
Una pregunta, ¿puedo hacer una pregunta? Una pregunta.
I have a question. May I make a question? Can I ask a question?
El señor Oskel, el otro muchacho, él también está aquí porque la corte de él a las 2:30, 2:30, a las 2 de la tarde, a ver si él también, si no sé, si es para las 2 de la tarde o él puede presentar, porque él quería también un término para ponerlo, no sé, o quedarse con el abogado, un término, no sé cómo la cosa.
Mr. O'Kell is here with me. He has court at 2:00, and he wants to know if he can be heard at this time.
Not without his attorney.
No sin su abogado, señor O'Kell.
He needs to log back on for his court appearance this afternoon, and his attorney.
Necesita conectarse otra vez esta tarde a las 2 de la tarde para que esté presente su abogado.
Ok.
Okay,
Thank you. Ileana, thank you.
gracias. Thank you. Is that it? That's all you need me for today? Or do you have another Spanish speaker case?
That's all I show for today. If I'm wrong about that, we'll have somebody call you, but I don't think so. I don't think we have anything.
Thank you, Judge Wood.
Thank
He
you.
needs to come
Thank you
back
very much. Have a nice day.
For him.
Ileana.
Oh, yes, I'm here.
If she had- meeting.
He always interprets.
Are you available for the 2:00 for the gentleman that just spoke?
Yes, yes, I am. I have it. In fact, I have it in my calendar already. Yes, Your Honor.
We'll see you at 2:00 then, if you can still make.
Okay. Thank you very much. Bye.
Yo no puedo llamar. Yo no, se puede ir preso, me quedo más abogado. No tiene que ver nada, es un abogado normal.
Hey, Brittany, can you hear me? She's muted. Can you get her unmuted?
Yes.
Okay. Hey, there you are. So listen, because we're on kind of an open mic, I just wanted to, what we had talked about was, pleading to a misdemeanor and going on probation and transferring to Oklahoma. Do you still want to do that?
Yes, sir. I just found out that my mom has her own house. It's 3 bedroom, so I'm able to move in with her. She already knows.
Okay.
For the transfer.
If you're good with that, we can do that today.
Oh, are we gonna do transport today? Like I should call my mom today?
Well, I don't know. It'd probably be done in the next couple days, but we might be able to do the plea today and then get you released in the next couple days. Would that be okay?
Yeah, that'll be okay. Can you let me know like a day before so my mom can come down here? She lives like 4 hours away.
Sure.
Okay, thank you.
Mhm. Well, do you want to do, I mean, we can continue it a week and then,
I think we already got our ducks in a row, so I mean, I think we.
okay, we'll go ahead and, okay, that'll work.
All right, thank you.
Mhm.
Okay, Mr. Randall, we're ready for your docket. Got recording going. Who would you like to start with?
Miss Medford is in custody, Your Honor. I believe we can start with her.
Okay, I've got 3 matters, 2024 CR 135, 24 CR 147, 24 CR 148, all the state of Kansas versus Brittany Mefford. Counsel, your appearances.
Thank you, Your Honor. Larry Marchinsky on behalf of the state.
Thank you, Your Honor. May it please the court, Chris Randall for Miss Mefford, who appears in person in custody from the Sumner County Jail. Actually, I'm sorry, she appears via Zoom and is in custody in the Sumner County Jail.
Thank you. All 3 matters on for status conference today. Mr. Randall, what can we accomplish?
Your Honor, I spoke with Miss Medford and I spoke with the county attorney, and we have come to an agreement that although we haven't specified the case, but I believe that she would plead to count 2 of Sumner County 2024 CR 135, which is a Class A misdemeanor. The remaining counts and charges would be dropped. And then the recommendation would be that she have a 12-month jail sentence, that be suspended and she be placed on probation and be allowed to transfer her probation to Oklahoma. She does not have a place to stay and was actually homeless. There was a mental health issue. She is currently on medication, and her mom has a house in Oklahoma, and that's where she's actually going to reside if the court allows her to go on probation, Your Honor.
And anything else, any other action in the other two cases?
No, Your Honor.
Again, sorry, the state's going to dismiss those other two cases, based on a plea to the 135 case. I concur with Mr. Randall in his assessment of the plea. The only thing that I would add to that is that during the pendency of all this going on, Ms. Mefford has been subject to a care and treatment case, and the state is going to request a special condition of her probation that she comply with the outpatient treatment orders as set forth in that Sumner County care and treatment case. But outside of that, I concur in Mr. Randall's statements, and the state's ready for a plea.
And Your Honor, I concur with the state's additional conditions.
Ms. Mefford, anticipated you're prepared to enter a plea of guilty to count 2 in 24 CR 135 misdemeanor theft. Is that in fact what you'd like to do?
Yeah.
And explain certain rights to you. I'm going to ask you various questions. If at any point you don't understand a question, please ask me to repeat it or explain it. If at any point you want to take a recess, talk to Mr. Randall, all you have to do is let me know. Do you understand that? Are you currently under the influence of any alcohol or illegal narcotics?
Do what?
Are you currently under the influence of any alcohol or illegal narcotics?
No.
I'm sorry, did you say no?
Yes, I said no.
Do you currently take any medication or supplements that might affect your ability to comprehend and understand what we're doing today?
No.
You understand you have a right to a jury trial in this case?
Yes, I do.
You understand to be found guilty, a 6-person jury would have to unanimously agree that you're guilty of this crime.
Okay.
You understand the state of Kansas must prove your guilt beyond a reasonable doubt and that you're not required to prove anything.
All right.
You understand you maintain a right not to incriminate yourself and a right not to testify at any trial.
Yes.
You understand you're not required to plead guilty today?
Yes, I do.
That meaning we could have a trial and it's at your choice.
Yes, this is my choice and I know.
Okay. You understand if you plead guilty today, you basically agree and admit that you've done what the state of Kansas alleges you've done in count 2 theft misdemeanor.
Yes.
You understand if we plead guilty today, we do not have a trial.
Yes.
You understand if you plead guilty today and we do not have a trial, you lose the right to have appealed trial errors that may have occurred if we had the trial.
Correct.
You have any questions about those rights?
No.
Is it your desire to give up all of those rights and enter a plea today?
Yes. And that means that the charges on my son would be dropped, right? Like the protective order?
Brittany, correct. The other charges are dropped.
Okay, thank you.
If there's a PFA in place, which there was, this does not affect that.
Okay. So I still can't contact my son?
That's correct, Ms. Medford. When we conclude this matter and you get out of custody, please give our office a call and we'll be happy to discuss it further.
Okay.
Mefford in 24 CR 135 as to count 2, alleging a violation of KSA 215801A1 theft occurring on about the 16th day of May 2024 in Sumner County, Kansas. How do you wish to plead?
Guilty, I guess. Honestly, that's the theft that you're talking about, right?
That is theft, a misdemeanor occurring in May 16th of 2024 in Sumner County.
Okay.
You plead guilty?
Yeah.
Mr. Marcinski, brief factual basis on that count.
Sure, Judge. Sorry. Should this matter have proceeded to trial, Judge? The state believes it could have shown through the presentation of witnesses and exhibits that on or about May 16th of 2024 here in Wellington, Sumner County, Kansas, that Wellington police officers were dispatched to an alleged theft out of a vehicle, a Dodge Avenger, belonging to a Mr. Drake Martin. Let's see.
Yeah, that was whenever I came.
During the investigation, after making contact with Miss Mefford, officers again made contact with Miss Mefford. She showed us a bag that she was carrying. In that bag was seen papers and miscellaneous items. Miss Mefford advised police that she had taken those items from Mr. Martin's car, again a 2008 Dodge Avenger. In speaking with Mr. Martin, he advised that she did not have permission to take those items out of his car. And those items were recovered and returned to Mr. Drake at that time. So the state's evidence in regards to the theft would be that on about that date that she took items belonging to Mr. Martin without his permission with the intent to permanently deprive them until she was apprehended, and then those items were returned. So that would be the state's basis of the theft count in 24 CR 135.
I was going to take him to the
Ms.
jail.
Medford, Ms. Medford, please do not address anything further. We'll talk offline. And the only time you need to talk is when Judge Wood is directly asking you a question. Okay?
Okay.
Thank you.
Ms. Mefford, do you agree that the state has evidence sufficient to prove you guilty if we had trial?
Yes.
Are you in fact guilty of this crime, misdemeanor theft?
Yes.
Court will accept your guilty plea, find you have voluntarily, knowingly, and intelligently waived your constitutional rights to enter the guilty plea today. Court finds factual basis for that plea and further finds you understand the nature of the charges and the consequences of your guilty plea. Court will find Brittany Mefford guilty as alleged in count 2 of Sumner County case 2024 CR 135. Pursuant to plea agreement, the court will dismiss the remaining counts of that case, would dismiss 2024 CR 147, 2024 CR 148 in their entirety. Recommendations from the state.
Again, Judge, it would be that the court consider imposing a 12-month underlying sentence on Ms. Mefford, but immediately suspending that sentence to probation with the court service department. In regards to these cases, there was no permanent loss of property. Everything was returned to the victims. So again, as I'd stated prior to the plea, the state's really only condition here is they are requesting. I should have pulled up the case number, Judge. Miss Mefford, in the last few weeks, we had a care and treatment case. I think it's 24 CT1, honestly. So the state is asking as a special condition of her probation that she be ordered to comply with the outpatient treatment orders in that case, follow through on those orders. I'm sorry, Judge, it's 24 CT2 is the case on Miss Mefford, the care and treatment case. In discussions with Mr. Randall and learning Miss Mefford's living situation, I don't have any objection to her being able to transfer the probation or to report from Oklahoma. It was reported when all these cases sprung up that she was homeless here in Sumner County. So the state's certainly supportive of her getting into a situation where she has stable residence. I think that would be best for her mental health. So I think that's all I have, Judge, unless you have any questions.
Thank you. Mr. Randall, any further recommendations?
No, Your Honor.
Ms. Mefford, anything you'd like to say in mitigation of punishment? You're not required to say anything, but this is your opportunity if you wish.
No.
All right. The will be order and judgment of this court. Ms. Mefford be sentenced to serve a term of 12 months in the Sumner County Jail. She's to be given credit for time served. Court will suspend the balance, place Ms. Mefford on supervised probation with court services. Special condition of probation that she will comply with any and all recommendations and successfully complete those recommendations stemming out of 24 CT2 Sumner County. Ms. Mefford will pay court costs, a booking fee, a probation fee. Mr. Randall, does she wish to be heard on attorney's fees? Anything else on that, I guess?
No, no, Your Honor. The only additional thing, and you may be covered, this is just that we would ask that the court allow her an opportunity to transfer probation to Oklahoma.
Court will authorize transfer of probation to Oklahoma after she successfully signs up with Sumner County. Ms. Mefford, I'm going to cap your reimbursement of attorney's fees to $100, but Mr. Randall will submit for full reimbursement. So your obligation is $100 for the attorney's fees. Ms. Mefford, once you're processed out, you'll immediately report to court services here in the courthouse and sign up for probation. Do you have any questions about that? Mr. Beveridge, any special directions from the court services?
No, Your Honor, I'll just reiterate what you just told her. As soon as you're released from the jail, please report to court services in the basement of the courthouse.
Brittany, you'll need to call your mom immediately. Let her know that you'll likely be released today and to come get you.
Okay, thank you.
All right. Ms. Mefford, if you have no other questions, good luck to you on probation. We'll get our paperwork over there and you'll get you processed out.
All right, thank you.
Thank you.
All right, folks, you ready?
Your Honor, I have one that could be disposed of very quickly. Jeremy Davis, we're going to be asking it to be continued to the 29th, and he is out of custody and in the courtroom. If you want to take that one up next.
24 CR 96, the state versus Jeremy Davis. Larry Marcinski for the state, Chris Randall with Mr. Davis in the South courtroom. Mr. Marcinski, any objection to a continuance?
No, Your Honor, thank you.
What was that date again, Mr. Randall?
August 29th. He also has CR 122 as well. He has 2 cases. August 29th, Your Honor, if that pleases the court. Mr. Davis is here in the courtroom. We spoke to him. We're setting up an appointment. We have not received discovery yet and just have not had an opportunity to speak with him. But we would just ask that both those cases be set to the 29th and he'd be released today. Or I should say excused. He's out on bond. Same bond conditions.
Both cases to August 29th, 10:30. Mr. Davis, your bond will continue. Conditions of your bond will continue. You're ordered to appear with Mr. Randall August 29th at 10:30. You're excused. I appreciate your appearance. Mr. Randall?
Who's the adjuster? What's her? Oh, yeah, right. Oh, Rockhurst is pretty quick, Judge.
All right, 23 CR 300,030 state versus Brock Hurst. Marcinski for the state, Chris Randall for Mr. Hurst. He also appears via Zoom application. Mr. Randall, go ahead.
If we could put that also on the 29th, Your Honor. He's diversion. He's put in everything. We're just waiting on him to complete.
Mr. Marcinski?
No objection, Judge. I thought we'd filed a stay on that, but I could be incorrect.
It might be the desk for me to sign. There is a stay of proceedings for one of Mr. Randall's cases. So,
but no objection to just continuing it for status or make sure that.
Okay. Mr. Hurst, your next court appearance, August 29th at 10:30. You're ordered to appear. Bond continues. Conditions of your bond continues. If you hear from Mr. Randall that everything's been filed and you do not need to appear, that'd be fine. You understand that?
Yes, sir.
I appreciate your appearance. Appreciate your patience. Mr. Randall, next case.
Mr. Jester.
21 CR 310, State versus Jonathan Jester. Council appearances on that, please.
Larry Marcinski on behalf of the state.
Thank you, Your Honor. May it please the court, Chris Randall appears from Mr. Jester, who is currently in custody. Your Honor, on that one, are you ready for me? So this is the one, Mr. Jester and I met, we talked, and he gave me authority to enter into a plea agreement based on certain circumstances. We spoke with the county attorney in person, and we did come to an agreement that Mr. Jester will plead to counts 4 and 5, which are 2 severity level 9 thefts. The recommendation from the defense and the court would be that those counts run concurrently and that the sentence run consecutively to what he is currently incarcerated on. He is currently incarcerated in Winfield, although he's currently incarcerated temporarily in the Sumner County Jail for purposes of the plea today. He is serving a DOC sentence in Winfield. We spoke and I informed him that if the state accepted the plea offer, that we would go forward with that today and that we would do that on the record. He said that he understood that, and because of that, I haven't talked to him since. So I know you're going to go advise him of his rights, but he understood, and the essentially information was that if we came to an agreement on that, then he was willing to proceed today. We did come to that agreement. So my assumption is that that is still good to go. that it would be those two counts run concurrently, but run consecutively to his DOC sentence. And then he would be, of course, ordered to pay restitution and get an expedited sentencing date. We believe he's a criminal history A, and that we have an expedited sentencing date so he can return to Winfield, or in the alternative, which we would actually prefer, is if the court could release him back to Winfield Correctional Facility at the conclusion of his plea, and that we do his sentencing via Zoom from the Winfield Correctional Facility. And the reason we would ask that, Judge, is he's actually doing very, very well with classes, and he's starting a new one. I just don't want him to miss any. And that's all, Your Honor. Thank you.
Mr. Morsinski.
Yes, Your Honor. I think the only thing is that I advised Mr. Randall I was going to request at least the opportunity to request restitution at the time of sentencing. I'm reviewing the case now. Honestly, I don't even see that there's any in here, but outside of that, I agree with Mr. Randall's assessment. The agreed plea agreement, plead to counts 4 and 5. State's going to recommend that they run concurrently to one another, but consecutive to his current incarceration. And again, I'm asking that I be allowed to argue for restitution at the time of sentencing, should that be requested of me prior to that. And that's all I have, sir.
Thank you.
And Judge, if I may, I think I said this earlier, that we were both concurrently recommend the low number in the box. Again, I anticipate him to be an A. And then as far as the restitution, we have no objection to the state requesting and arguing for restitution at time of sentencing.
And I do concur with that, Your Honor. I did advise Chris in exchange for a speedy plea and getting Mr. Jester on his route that I would recommend the court consider imposing the low number in the appropriate box. That is a true statement.
Thank you.
It's 4. Yeah, it's 4. It counts 4 and 5.
It's two. That's what it was. Yeah.
Yep. Because count 2 is misdemeanor. Yeah.
All right. Mr. Jester, you have a right to preliminary examination as you've been charged with a couple of felonies, so I'm going to go through those rights.
Yeah.
Pardon me, I'm sorry. Technical difficulty or. Mr. Jester, for you, I ask if you're going to waive your right to prelim. Want to make sure you understand certain rights. Again, being charged with at least one felony by complaint, you have the right to preliminary examination. You have the right to present evidence in defense of the allegations. You have a right to have the state's witnesses examined in your presence. You have the right to have your attorney cross-examine those witnesses. If from the evidence presented, it appears that a felony has been committed and there's been probable cause to believe you've committed that felony, you'll be bound over for an arraignment. If from the evidence presented, it appears that a felony has not been committed or that there's not probable cause to believe you committed that felony, this case would be dismissed and you'd be discharged from any further obligations relating to these proceedings. Any decision to waive your right to prelim is final and you'll not be given another opportunity at a later time if you change your mind. Mr. Jester, do you understand all of those rights?
Yes, sir.
Those rights and advisements in mind, do you wish to waive your right to statutory right, to preliminary examination?
Yes, sir.
Court will find defendants knowingly and intelligently waived his right to preliminary examination and would accept that waiver. Does the state also waive its right to prelim? Mr. Marcinski.
I'm sorry, Judge.
Does the state waive its right to prelim?
Oh, yes.
Mr. Jester, you'd be bound over for an arraignment. Arraignment's a process where I would complain to you, explain the charges contained in the pleading in any possible maximum sentence. If you're comfortable with your understanding of what you're charged with, maximum possible sentences, your relationship with Mr. Randall, his explanation of what's going on. If you're comfortable with this plea agreement, you can also waive formal arraignment. Would you like to go through formal arraignment, or are you comfortable enough to waive that arraignment?
As long as it's the agreement that we spoke of, I'll waive it.
Formal arraignment gets you to the agreement you've been discussing. Yes, sir.
Okay, yeah, then I'll waive it.
All right, and we said 4 and 5, is that correct?
That's correct, Your Honor.
Mr. Jester, do you need any further time to speak to Mr. Randall before we go forward on counts 4 and 5?
No, just, there won't need to be an argument about restitution. I'll accept any restitution that's due on it. I just wanted to state that. That's it.
Okay. I'm going to explain other rights to you, sir. I want to make sure you understand those rights. If at any point you do not understand one of my questions, just ask me to repeat it or explain it. If at any point you want to take a recess, talk to Mr. Randall, all you have to do is let me know. Do you understand that?
Yes, sir.
Mr. Jester, are you currently under the influence of any alcohol or narcotics?
No,
You currently take any medication or supplement that may affect your ability to understand and comprehend what we're doing today?
no,
You understand you have a right to a jury trial in this case?
yes,
You understand that to be found guilty by a jury, a 12-person jury would have to unanimously agree that you're guilty of these crimes.
yes,
You understand it's the state's obligation to prove your guilt beyond a reasonable doubt and that you're not required to prove anything, including your innocence.
yes,
You understand that if we had jury trial, the state of Kansas would have to bring in witnesses to testify against you in open court.
yes,
You understand that you and your attorney would have the opportunity to cross-examine the state's witnesses and then ask questions in your defense of the allegations.
yes,
You understand you have the right to use the power of subpoena to find and compel the appearance of witnesses to testify in your defense and on your behalf.
yes,
You understand you maintain a right not to incriminate yourself and a right not to testify at any trial.
yes,
Sir, do you understand you're not required to plead guilty today?
yes, sir.
You understand if you plead guilty to counts 4 and 5, you basically agree and admit that you've done what the state of Kansas alleges you've done in counts 4 and 5.
Yes,
You understand if you plead guilty today, we will not have a trial that we've been discussing.
yes,
You understand that if you plead guilty and we do not have that trial, you lose any right to appeal trial errors that may have occurred at that trial.
yes.
You have any questions about those rights?
No, sir.
Is it your desire to give up and waive these constitutional rights to enter guilty pleas today to counts 4 and 5?
Yes, sir.
The plea agreement between you and the state of Kansas has been proposed and discussed in court today. Do you fully understand the plea agreement?
Yes, I do.
You understand that any agreement between you and the state of Kansas about sentencing is not binding on this court and will only serve as a recommendation to this court.
Yes,
You understand that when we have your sentencing hearing, this court will do whatever it believes is appropriate within the limits of the Kansas Sentencing Guidelines Act and allowable by law.
yes,
You understand you retain the right to appeal this court's sentence if you believe it is imposed illegally or contrary to law.
yes.
Other than the plea agreement, has anyone promised you with anything or threatened you with anything to convince you to plead guilty today?
No,
Has anyone promised you would receive probation?
no,
You understand that you could be sentenced to serve, and I understand that's probably the intent, to serve a prison term. Some recommendations about concurrent counts to one another, but consecutive to other cases. You understand you could be sentenced to prison on these cases.
yes,
You understand if ordered to pay restitution, fines, fees, or costs, that doesn't necessarily just go away because you're in prison, and that obligation would see you on the other side.
yeah,
Have the services of Mr. Randall been satisfactory?
yes, sir.
Do you have any complaints about the way Mr. Randall has represented you?
No,
Do you have any complaints about the way the court has treated you?
no,
Sir, to the counts alleged in Sumner County Case 2021 CR 310, specifically count 4, violation of KSA 215801A1 theft, a severity level 9 non-person felony occurring between the 4th and 7th days of May 2021 in Sumner County, Kansas. How do you wish to plead?
guilty.
And to count 5, alleging a violation of KSA 215807A3, burglary of a vehicle. Also a severity level 9 non-person felony occurring between May 4th and May 5th of 2021 in Sumner County, Kansas. How do you wish to plead?
Guilty.
Mr. Marcinski, brief factual basis.
Judge, I'm going to do the best here. This is a pretty long, detailed case, a lot of investigation by the sheriff's department. Obviously, as the court can see, there was multiple charges here the state's dismissed and working out this disposition. But essentially, as best as I can boil it down, Sumner County Sheriff's detectives were investigating a series of thefts and burglaries in the county on or about, I believe, May 4th or May 5th of 2021. They were dispatched to an address of 1621 East 50th Street out in the rural Sumner County. It was determined that somebody had gone through an open barn and taken from inside that barn a 1986 flatbed Chevy pickup truck. That truck also included several farm implements, a large tank, and some sort of pumps on it, along with some hand tools, yard tools type of situation. Law enforcement officers, both in Sumner County and Cali County, are continuing to investigate a series of thefts and burglaries throughout the two counties. On May 6, 2021, Sumner County Sheriff's officers were advised by Kansas City Police that the 1986 flatbed Chevrolet pickup truck had been discovered at a Quality Inn on the north side of Ark City. In responding to that and looking at the pickup truck, it was determined that the tanks and the pumps were still on there, but the hand tools and yard tools were missing. At that time, it looks like sheriffs did some DNA swabs. It was also determined in a follow-up investigation with the victims of that address on May 11th that a beer bottle was left on a flatbed pickup or around where the flatbed pickup truck had been parked inside that barn. The victims advised law enforcement that they didn't know anything about that beer bottle. It wasn't theirs. There was a successful fingerprint lifted off of that beer bottle. Ultimately, Mr. Jester was arrested. Sumner County Sheriffs did have an interview with him. I thought that it said in here at some point that he acknowledged being in possession of the 1986 Chevy flatbed pickup truck. I would note, for the purposes of restitution, it does say that everything was recovered, so I don't think any property was ultimately lost. And then it does appear that the sheriffs did send in the fingerprint and the DNA. Then the report doesn't indicate if those came back to Mr. Jester, but I believe that they did. So the state's evidence in regards to the burglary of a vehicle would be that Mr. Jester entered into that 1986 Chevy flatbed pickup truck with the intent to commit a theft or other crime therein, the theft being that of the truck itself, which is an acceptable theory under Kansas law. And that the theft would have been the 1986 Chevy pickup truck and or the hand tools that were taken out of the back of it. And again, those were all ultimately recovered and returned to the victims. But that would be the 50-foot overview of this rather detailed investigation that led to Mr. Jester.
Mr. Jester, do you agree the state has evidence sufficient to prove your guilt if we had jury trial?
Yes, sir.
Are you in fact guilty of these two crimes?
Yes.
Court will accept your guilty plea, find you have voluntarily, knowingly, and intelligently waived your constitutional rights to enter your guilty pleas today. Court finds factual basis for your guilty pleas and further finds that you understand the nature of the charges and the consequences of your guilty pleas. As such, the court will find Jonathan Jester guilty of counts 4 and 5 of Sumner County case 2021 CR 310. Pursuant to plea agreement, the court dismisses the remaining counts of that complaint. Court orders a pre-sentence investigation to be completed. Mr. Beveridge, how long are those taking?
4 weeks should be sufficient, Your Honor.
Thank you. That would be August 15th. We've been moving things to the 22nd because that's a jury trial week for both Judge Mott and myself. Mr. Randall, what's that timeline look like for
If
Mr.?
we could do August 29th, Your Honor, and again, I know the court will probably address this, but especially if he could be released back to DOC and we could just do the sentencing from Winfield Correctional.
Mr. Marcinski?
I don't have any objection to that, Judge. I mean, it'd be easier if he was here, but we've done Zoom from Winfield before. As long as Megan doesn't think she'll have any trouble getting that set up for us, I don't have any objection to him going back to DOC.
And Your Honor, as far as he'll completely cooperate with the pre-sentence investigation. As I said, Mr. Jester and I had very good conversations prior to coming in here. We have no doubt or feel very strongly he will be found to be a criminal history A. So I don't think there's going to be any logistical issues or objections to the PSI report.
Okay. Court will set sentencing for August 29th at 10:30. Counsel, or I guess I'll go with Mr. Randall. If you'll file a notice of hearing with the Zoom information, make sure whatever correctional facility he's placed at has a copy of that for their purposes.
I will do so, Your Honor.
All right, Mr. Jester, you're required to speak to court services as they direct for the preparation of the PSI. You're required to cooperate and provide certain information. If you have any questions about the level of cooperation or information you're required to give, that's a question for Mr. Randall, for you to ask Mr. Randall. Do you understand that?
Yes.
PSI has to be completed before we can have your sentencing and before this case can be disposed of. Mr. Jester, do you have any questions about what's happened today?
No, I don't.
Okay. Mr. Randall, anything else from you for the defendant?
Yes, Your Honor. May I, with the court's permission, include in the notice of hearing Zoom that the court has authorized a return to custody of the Kansas Department of Corrections?
Yes, sir. The court, I'm not sure how you want to do that, Mr. Marcinski, for any bond that I guess got him down here, could be converted or modified. Any order to transport, we can show that as expiring to return him or do another one. I don't care.
And I will say, Your Honor, on that note, I do believe he did file a request for the Detainer Act, which will require the state then to bring him to court within 6 months. We would agree, and on the record, that the state has fully complied with the Detainer Act, and that the statutory requirements that the state has adopted in regards to the Detainer Act have been complied with by the county. And for those reasons, there would be no grounds for a motion to dismiss. And we would also further agree that his return to Winfield Correctional Facility would not in any way restart the clock, and he would further waive any Detainer Act rights that may arise from his returning to DOC. In other words, Your Honor, the defense will not be attempting to do any type of funny games or bait and switch that he's returned back and say that there's some Detainer Act issue. We would fully waive and acknowledge that that has been satisfied by the Sumner County Attorney, Your Honor. And that's all I have.
All right. Thank you. Mr. Marcinski?
I don't have anything to add to that. I concur with what Chris has said. I appreciate his statements. I try. But I don't have any problems getting Mr. Jester back to Winfield. We'll prepare a transport order as long as that notice of hearing. And like I said, we've done Zoom from Winfield before, so I don't see it being an issue.
Okay. All that to be authorized by the court, sentencing August 29th, 10:30. Mr. Jester, good luck to you, sir.
All right, thank you.
Mr. Randall, your next case?
Robert Ziner. Is Robert Ziner in the court?
He's on Zoom.
24 CR 144, State versus Robert Ziner. Is he on Zoom?
It's Douglas Erickson is the name on his Zoom screen.
All right, Mr. Ziner, you need to unmute if you can. I'll send you a prompt. Larry Marcinski for the state, Mr. Randall for the defendant in the courtroom. Mr. Randall, what's the announcement?
So on that, Your Honor, Mr. Ziner and I have talked extensively, and if he wants a breakout room, obviously we would ask the court for that. We had talked, and Mr. Ziner and I had agreed that it was in his best interest to offer to the state if he could plead to a Class A misdemeanor, have an underlying sentence, and then be released onto probation, and that he'd be allowed to go home. Mr. Zeiner had said that that is something that he would agree to if he still wants to do that. And I think we can proceed today. If he wants more time to talk to me, I'm fine with that as well. If the court's inclined to go forward with that today, Judge, what we would ask is that we go forward with that sentence today and he be allowed to go home. As a little bit of information on the case, the alleged victim in the case is his wife of 34 years. And they have had through the years a little bit of an eccentric relationship. His wife does want him back home, and he doesn't have a place to stay. So we would ask, if the court is inclined to take the plea today, that we would ask that he be allowed to go home and have contact with the alleged victim, which is what she wants as well. That's all I have on that, Your Honor. And if Mr. Zeiner wants to proceed today, we are happy to proceed if it pleases the court.
The only problem with that, if I might interject, is that I currently have Mr. Zeiner charged with a felony aggravated domestic battery pursuant to plea negotiations. I've agreed to amend that down to a Class A domestic battery. Second within 5 years. I don't have a complaint on file for that, so I don't know if the court would be willing to. It is a lesser included, or if the court would prefer to me to draft a complaint real quick, or how we want to do with that. But the current complaint on file with the court is for aggravated battery, but I have agreed and concurred to a plea to Class A misdemeanor domestic battery. So I don't know.
And Your Honor, in regards to that, if obviously if we two things, obviously, and it is going to obviously be the purview of the court. If the court wants to proceed with the plea today, which we're happy to do, if the court does that, we do have a motion on file for a bond reduction. I'm sorry, not a bond reduction, a bond modification. The plea would then, of course, make that motion moot.
Right. How about this? Mr. Marcinski, does the state have any objection to the motion to modify bond? That may answer our second question, or my second question.
Yes and no, Judge. I mean, Mr. Randall and I discussed this at length this morning. Ultimately, I have agreed to what they're asking for, which is to allow him to plead to a misdemeanor, go on probation. And as part of that, obviously, the bond contact or the no contact provision through the bond would be moot at that point. So ultimately, I have agreed to that. Obviously, the state up until today has objected or opposed any modification of bond due to the number of prior incidences between Mr. and Mrs. Zeiner. I will advise the court, as I did Mr. Randall, that Ms. Zeiner has come into my office and essentially made exceptionally clear to me that she does not want that no contact order. So it's a tough one for me. I think that we're getting on the right side of things, and I'm hopeful for the future moving forward with the disposition we have. I understand Mr. Zeiner's issue of not having any other place to go besides the marital residence. So I guess no objection, Your Honor.
Your Honor, if I may also add an addendum to that.
Go ahead.
So I spoke with Mr. Zeiner about this, and Judge, if you're inclined to modify the bond, then we would just ask that we either move the case a week or move it to the 29th of August, where we could enter the plea and Mr. Marcinski could then file the amended complaint. I did talk with Mr. Zeiner too, and I mentioned to him, and I think he's very aware of this. I told him, I said that we had been in your courtroom many, many times, and I said that I can tell you from, this is me talking to him very candidly, that Judge Wood takes every single thing into consideration and does weigh heavily many times on how somebody and how they perform while out on bond. And in that regard, Your Honor, Mr. Zeiner has been informed, and I feel very confident that he completely understands that he is pleading to something that carries an underlying sentence of 12 months and that we are asking for a complete suspension of that sentence and that he be placed on probation. Also informed him, and I believe that he is fully aware that if this bond is modified, he goes home and an additional incident takes place and the police are involved again, that it will probably weigh heavily on the court when it comes to whether or not the court is going to give him probation for the entirety. And so the reason I say that, Your Honor, is I do want you to know that Mr. Ziner and I did discuss that thoroughly. So if the court is inclined to grant the bond modification, I do want the court and the county attorney to know that I did speak with Mr. Ziner at length about those conditions. He understood. In other words, if we let him go home and something happens again, I don't want to use a bad metaphor, but it could be problematic to his case, and he fully understood that, Your Honor. That's all I have. Thank you.
Thank you. Mr. Ziner, I take Mr. Randall at his word. He informs me and his clients quite well. You understand if I grant your motion to modify bond, your court appearance will be moved for 7 days. So to July 25th, you'll appear in person with Mr. Randall to effectuate your plea. Any hiccups between now and then, you'll sit without bond on the new charges, and you can probably guess what'll happen for your sentencing on this anticipated plea, just so we're on the same page. You understand all that?
Yes, sir.
All right. This motion modified bond filed July 3rd will be granted. Ask Mr. Randall to prepare an order answering that motion. We're going to show up for plea July 25th at 10:30. Mr. Ziner to appear in person.
Thank you, Your Honor. We will prepare that order and submit it for the court signature.
Mr. Ziner, good luck to you. We'll see you in about 7 days. Do as you've represented and what we talked about.
Thank you, Your Honor.
Mr. Ziner, just give us a call. You won't need to be on Zoom anymore, but please give me a call in the next couple of days so we can discuss things further outside of court.
Okay, I will.
Thank you, Robert.
Thank you.
Thank you.
Mr. Randall, your next case?
Chris Shapley, who's in person, Your Honor, at sentencing.
Two matters, 24 CR 10, 24 CR 21, both the state of Kansas versus Christopher. Shapley, counsel your appearance.
Larry Marchinsky on behalf of the state, sir.
Your Honor, may it please the court, Chris Randall for Mr. Chris Shapley. Chris is here sitting next to me and is in person in the Sumner County Courthouse. Yeah, chair. You should be able to see him on camera, Your Honor. He is in the red chief shirt sitting in between myself and my paralegal.
Got it. Thank you. All right. Here for sentencing in both cases. CR 10's a felony, CR 21's misdemeanor. PSI have been filed in the CR 10 case June 24th. Have counsel had sufficient opportunity to review those PSI?
Yes, Your Honor.
Yes, Your Honor, the defense has, and we have no objection.
All right, Mr. Marcinski, if applicable, have the provisions of the Victims' Rights Amendment to the Kansas Constitution been complied with?
We do our best, Judge. Let me take a look. In regards to 24 CR 10, I do see that we have sent notifications to the victim as recently as May. We've sent those individuals at least 5 letters. So I would be of the belief that we have complied with the Victim Bill of Rights in that case. And I would make the same statement in regards to the 24 CR 21 case. I do see that we've sent multiple letters out, including most recently one on June 25th, advising them of today's date. So the state does believe it has done its best to comply with the Victim Bill of Rights.
And it appeared about May 30th earlier this year, entered pleas in CR 10 count 1. Court accepted his plea, found factual basis for that plea, found him guilty of that crime. Does either party have any disagreement with the criminal history worksheet contained in the PSI?
No.
No, Your Honor.
Mr. Shapley, do you agree and admit that the criminal history set forth in the worksheet is true and correct to the best of your knowledge?
Yes, Your Honor.
Very good. The court will find defendant's criminal history score is E. Primary offense is count 1, burglary of a motor vehicle, violation of KSA 215807A3. That is a severity level 9 non-person felony. Court will find the presumptive guideline sentence for the primary offense is a minimum prison term of 9 months to a maximum of 11 months, with 10 months being the mid-range sentence. Sentence carries recommended post-release supervision duration of 12 months. There's possible probation duration of 12 months. This is a presumptive prison sentence per special rules. Number 27 applies as this is a burglary and the defendant has 2 or more prior convictions. Does either party have any disagreement with those findings?
But no disagreement on behalf of the state, sir.
No, Your Honor.
Mr. Marcinski, state's recommendations and for both cases, please.
Thank you, sir. Judge, these cases are unusual. Mr. Shapley, as you can well see, has had some criminal history, but then for all intents and purposes, after 2014, things seem to be going well. And then all of a sudden, late last year, I don't know why, we have just a litany of cases. However, Mr. Shapley has been forthcoming in admitting his guilt and taking responsibility for these cases. The state's plea agreement was to recommend the standard number in the, I believe sometimes in these cases I will request low, so I would defer to Chris, but I believe my plea was to recommend the standard number. And I always use the standard language that I'm going to recommend the presumption or any special rules that might be applicable. I know that Chris and I talked about this case at length, and Chris did a very good job of convincing me that Mr. Shapley has turned a corner, has been doing well. So it was always our discussion and anticipation that the parties would recommend that Mr. Shapley get probation for these crimes. So for that reason, and based on our negotiations, I'm not asking the court to impose the optional prison sentence that it could based on that special rule. The parties have agreed that the appropriate outcome here would be probation. The state advised it would just recommend whatever probation supervision level was appropriate pursuant to risk assessment, which the PSI leads me to believe would be with community corrections. In regards to the misdemeanor case, the state's plea agreement was to request a 12-month underlying sentence. That sentence be run consecutive to the felony sentence, but that he be granted probation in that matter as well. Of course, the idea is to stack a somewhat lengthy underlying sentence on the defendant's head, but with an opportunity at probation to show that he can be a productive member of society and not have to face the prison sentence. One of our negotiated pleas, Your Honor, was that the state was going to request restitution on behalf of the victims in the dismissed cases. And so for that reason, the state is requesting, and these are victims that are related to dismissed cases, but the state is requesting $190 in restitution to Mr. David Eagle. To be clear, he was the victim in the 24 CR6 case, which the state has dismissed. And I'm asking for $250 in restitution to Mr. James Ball, who was the victim in the 24 CR7 case, which the state dismissed as part of its pled out negotiated resolution here. So the state is asking that you consider imposing those restitution figures as a condition of the probation granted. We would ask that the court consider setting out a restitution repayment plan in regards to those. Outside of that, I just ask that you do consider granting Mr. Shapley probation based on the parties' agreement and based on the good things that he has been doing that the state took into consideration in entering this plea. And would ask that you impose all of the conditions set forth in the PSI, any of the appropriate costs, and again, would request restitution for those individuals in the amount stated. And that's, I believe, all I have, sir.
Thank you. Mr. Randall, recommendations for the defendant.
Thank you, Your Honor. We concur in that we would ask we have no problem with the standard sentence and the misdemeanor underlying sentence. We also concur and would ask that the court either not follow the special rule or depart and place him on probation based on acceptance of responsibility and the actions he has taken beforehand. What I will say about Chris is there are many reasons why I enjoy doing this docket. There are many reasons why I enjoy being a lawyer. Chris is one of them because Chris has been kind of one of those remarkable success stories. And like many property crime cases, they rely around drugs. Chris would be the first to tell you he's a drug addict. He had a meth addiction, and unfortunately, people steal things to support that addiction, and he got into a lot of trouble. Chris is a pretty remarkable story, and it's so remarkable that I actually didn't even recognize him in the courtroom today. He's 6 months sober. He works full-time at Subway. The court took his ankle monitor off so he could start swimming with his kids, which I joked is why he has a tan now. And he's very involved with his family. He has had no issues. He's sober for 6 months. Something kind of cool too is he's actually gained 28 pounds, which is why I didn't recognize him, because he is really living a great life. He's been going to NA meetings, treatment, and he is really doing phenomenal. In fact, of all the cases I've ever had, Chris is he's got to be in the top of it. Gained 28 pounds. He's been sober for 6 months. He's gainfully employed at Subway. He's involved with his kids. He's been absolutely the best client you could ever imagine. Every time we call, every time we have an appointment, he's there. He was the first one in the courtroom today. I think he got here a half hour early. He's really just been awesome. He is such a great success story that I know it's my job to advocate on his behalf because that's what I'm getting paid to do. But I would advocate on his behalf even if I wasn't, because I think Chris has been a superstar. I think he got caught in the throes of addiction, but a country that loves second chances, Chris has made the most of his. Very proud of what he's done. I think he's going to be a superstar success on probation. He's been a great father. He's been a great employee, and he's been an absolutely exceptional client. I want him to stay on this track. He knows he's got a big underlying sentence, and I think that will be a big deterrent to him doing anything else. But honestly, Judge, I don't even think it's the sentence that's going to be the big deterrent, because I think Chris wants to succeed. I don't think it's a threat of jail that keeps him sober. I think he said he's doing awesome and he feels better than he ever has in his life. And I think that's what he wants to keep up doing. And so for all those reasons, Judge, I would hope that the court finds Chris to be the success story that I have. Obviously, and I've said this term before, none of us have a crystal ball as to what's going to happen in the future. But if past behavior is any indication of future behavior, then Chris has been pretty much a rock star for the last 6 months. And I feel very confident that he's going to continue in that. And for those reasons, Judge, we would ask that you follow the plea agreement. You place him on probation with community corrections with credit for time served. I will note, Your Honor, Community Corrections was here earlier. I talked with them in the hallway and I had them meet with Chris ahead of time. So if the court is inclined to put him on probation, he has spoken to Community Corrections and they have arranged to speak with him. Lastly, Judge, as I do with all clients, I told him, I said that this is the plea agreement, and as you knew when you took it, it's not binding on the court. Chris completely understood that. And so I don't want the court to think in any way we were presumptuous to say that we know exactly what the court's going to do. That wasn't it. But I told him that I said in the event that the court does follow the plea agreement, you will need to report immediately to Community Corrections. And because of that, Chris did meet with him today. That's all I have, Your Honor, pending any questions. Thank you.
Thank you. Is it Shapley or Shapley? I'm sorry.
Shapley.
Shapley. Mr. Shapley, do you wish to make a statement or present any evidence in mitigation of punishment? You're not required to say anything, but this is your opportunity if you wish.
No, Your Honor.
Does either party know of any reason, legal or otherwise, why a sentence should not be imposed at this time?
State knows of none, sir.
None from the defense, Your Honor.
Chris, do you know of any reason why a sentence should not be imposed at this time?
I do not, Your Honor.
Sumner County Case 2024 CR 10 will be the order and judgment of this court that the defendant be sentenced to 10 months in the Department of Corrections. That is the mid-range sentence. Court will impose post-release supervision duration of 12 months. Defendant may earn up to 20% good time credit towards his sentence. He's be given credit for any time spent incarcerated during the pendency of this case. PSI would indicate at least 25 days. Court will suspend the prison term, place the defendant on supervised probation with community corrections. And that will be for a period of 12 months. Court authorizes the supervising agency to utilize immediate sanctions as found in KSA 223716. In 2024 CR 21, it's the order and judgment of this court that the defendant be sentenced to serve a term of 12 months in the Sumner County Jail, that to run consecutive to the sentence imposed in 2024 CR 10. I didn't say it before. Those sentences and controlling terms will be ran consecutive to any other cases in any other jurisdiction that he might be facing. He'll receive probation in 24 CR 21, concurrent to the probation of 24 CR 10. Ask community corrections to supervise both cases for the same term. His probation includes the standard conditions of probation found in Kansas statutes. Further, he'll abide by any and all special conditions that were contained or included in the PSI. Chris, have you reviewed those special conditions of probation? You're subject to curfew, travel restrictions. You'll gain and maintain employment subject to urinalysis, blood or breath tests at your expense at the request of the probation officer. Do you understand all of that?
Yes, Your Honor.
You accept probation on all of those terms, special, standard, or otherwise?
Yes, I do, Your Honor.
Court orders all special conditions reflected in the PSI to apply to this probation. Defendant will pay court costs in the amount of $193 for 24 CR 10 and $158 for 24 CR 21. He'll pay a DNA database fee of $200 if he's not previously done so in his lifetime. He'll pay a one-time probation fee of $120. Pay the booking fee of $45. That's one time. And he'll pay the bids application fee of $100. Mr. Randall, does he wish to be heard on the issue of attorney's fees after the first bids application fee?
No, Your Honor.
Christopher, I'm gonna cap your reimbursement of bids attorney's fees to $250. I appreciate that you're working. I appreciate Mr. Randall's comments, actually Mr. Marcinski's comments as well, about you being on the right track. I don't need to overwhelm you with costs, but people do need to pay something back for the representation. So you'll pay bids application fee of $100 and an additional $200 in bids attorney's fees. The balance is waived for your reimbursement, and Mr. Randall to submit for full reimbursement. Restitution as part of probation, and it'll pay restitution in the amount of $190 payable to David Eagle and $250 payable to James Ball. Mr. Randall, workable plan of restitution for that amount?
Your Honor, I would probably, if we could, what I would ask is that be deferred to community corrections. And they could do a little bit of a deeper dive depending on his weekly income level and his bills, if that would be okay.
Well,
Because
I don't think we can do that anymore. We got
Oh, okay.
a monthly amount, so
50 a month, Your Honor.
440 over the 12 months is approximately $36, so $50 would certainly pay it off. Mr. Marcinski, do you wish to be heard?
no, thank you.
A workable plan of restitutions found by the court would be a $50 payment per month towards restitution. Then community corrections certainly has the authority to stagger or otherwise look at the other costs that have been imposed based on his financial resources and how that should be paid back. Counsel, other than expungement and appellate rights, is there anything I've failed to address or have overlooked?
Just in regards to the restitution repayment plan, you're ordering that first payment be due August 1st. Are you going to give them till October 1st or?
September, we'll call it September 1.
Okay, thank you.
Anything else from you, Mr. Randall, other than expungement and appellate?
No, Your Honor.
Christopher, you may have the right to expungement of these crimes under KSA 216614. That means after completion of your sentence or probation and after a period of time as required by statute, you may petition this court to seal or expunge these convictions. Do you understand that?
Yes, Your Honor.
Sir, you may have the right to appeal the sentence of this court if you believe it has been imposed illegally or contrary to law. If you wish to appeal, a notice of appeal must be filed within 14 days of today's date. Do you understand 14 calendar days from today, sir?
Yes, Your Honor.
If you wish to appeal, a notice of appeal can be filed by Mr. Randall. If you want to appeal, you need to let him know within those 14 days, obviously. I'll direct as his last act of trial counsel to file the notice of appeal on your behalf. In the event you appeal, and if you still qualify, an attorney could be appointed to represent you, and a transcript of the sentencing hearing would be provided for your use at no charge. Do you understand your rights to appeal?
Yes, Your Honor.
Sir, you're now a convicted felon. You've lost many civil liberties. As a convicted felon, you're prohibited from possessing firearms and various weapons as outlined in Kansas statutes. Further, you've lost the right to vote until your sentence has been fully discharged. Do you have any questions about your sentence or any other orders of the court that you've heard today?
No, Your Honor.
You will need to report to Mr. Bruner. Mr. Bruner, when would you like to see him?
Yes, Your Honor. Mr. Shapley, just go ahead and come on over as soon as court has convened, okay?
Okay, no problem.
Thank you.
Mr. Shapley, good luck to you on probation. Anything else from counsel on this case?
Not on behalf of the state.
Mr. Shapley, again, good luck to you. Do as we've directed.
Thank you, Your Honor.
Thank you.
All right, Chris. See you then.
Thank you. Thank you.
I think that concludes all my cases, Your Honor. May we be excused?
Miss Ruppert, she's been here for quite a while. That's with Miss Schmiedler though. So Mr. Randall, you may not have known about that yet.
Oh, okay. Oh, yeah, I am covering one for.
All right, 24 CR 29, State versus Stephanie. Is it Ruppert or Rupert? Rupert, yes, ma'am. She appears via Zoom application. Bailey Schmiedler's your attorney, but Mr. Randall is works with her or otherwise her supervising attorney, and he can appear for her and with you today. Mr. Larry Marcinski for the state. Mr. Randall, do you know what we need to do?
Judge, I might interpose if I might. Ms. Schmiedler's been working on Miss Rupert's behalf. They sent me photographs earlier this week. Basically, I advised the defendants in both of these cases, Miss Rupert and her husband, that if they sent me pictures of remediation of the issue, that I would dismiss the case. Let me say they did the very, very bare minimum that they could possibly do, but they did do what I asked them to do in remediating the endangering situation. So the state's going to go ahead and dismiss this one without prejudice.
Okay, Mr. Randall, any record?
No objection, Your Honor. Thank you. And I'm sorry, and no further record, Your Honor. I apologize.
Sure. The state's request, 24 CR 29 will be dismissed. State to file proposed order, please. Ms. Rupert, you are relieved of your obligations in this case, released of bond. You have no further court appearances. Do you have any questions?
No, Your Honor.
All right, thank you for your appearance and thank you for your patience.
Thank you.
And then Judge, I'm sorry, I showed we still had a Melanie Franklin This is a very new case. I just filed it, I think, yesterday. Bailey probably got appointed yesterday.
We've got, yeah, with 24-178 State and versus Melanie Franklin. I've got an order continuing that to the 15th of August at 10:30.
Oh, thank you.
All right. Mr. Randall, those are the cases I had for you. Do you have anything else for today?
No, Your Honor, I do not. Thank you.
Thank you for your appearance.
Okay, thank you, Your Honor. We'll see you next time.
Appreciate it.
Looks like there might have been order.
Thanks, Larry.
See you, Mr. Randall. Take care.
We'll catch up with you on the next 10 or 12 that we got.
Caswell.
8,
8 at 11. All right, Mr. Marcinski, Caswell matter at 11 with Mr. Schoenhofer goes to August 8th at 11 a.m. And then we'll have to discern between those two cases that she has.
Mr. Bryant Ross is being continued to 8 at 11 for the motion to suppress.
2024 CR 80, the state versus Bryant Ross also goes to August 8th at 11 a.m. to schedule a suppression. We'll have to schedule a hearing on a motion to suppress that's been filed.
Yes, Your Honor. Understood. Thank you.
Yeah. Yep, I've got Larry. It doesn't necessarily make Judge Mott's docket, but they are on my docket with Mr. Giles and Mr. Loftus.
Yes, Your Honor.
And then we've got at least one person in the jail to take up after these. So Mr. Giles, you were in first. CR 45, State versus Tyler Treft. Counsel, your appearance.
Larry Marcinski on behalf of the state.
Judge, the defendant Tyler Treft appears by and through counsel Chad Giles.
Thank you. Matter just on for status today. I think we previously set a prelim, and because of either just my calendar or because of everybody's calendar, we had to move that back to a status setting. Mr. Giles, what can we do today?
Judge, our plan is to request to get this back on the prelim docket for a prelim. Mr. Loftus is present with his client. I think at this point we want to remain as a concurrent prelim with both defendants at the same time.
Very good. And that's speaking about 24 CR 47, the state versus Tice Brees. Larry Marcinski for the state, Mr. Loftus for his client, Mr. Brees. Okay. Is that a half a day setting? I can't remember what we did last time.
I would think that should be appropriate, Judge. State
Yes.
called 4 witnesses at most. Probably not even that, honestly. State probably called 2 witnesses.
Aaron King's going. I took that off the docket, jury trial docket, because there's an interlocutory appeal. Counsel, I've got Tuesday, Wednesday, or Thursday, August 27, 28, or 29, and those should be wide open either morning or afternoon.
Well, the 29th is a Thursday, so I don't currently show we have anything on the docket that day, but I would try to steer away from that Thursday, but the 27th or the 28th, either one would be fine for me.
Scott, you're muted, Scott.
That rarely happens.
Yeah, Judge, I'm scheduled to be in a jury trial with an in-custody defendant here in Kate County that starts on the 27th. I would anticipate that it would go to the 29th.
Got all day Monday, September 9th, or the Friday the 13th.
I start a murder trial that week here in Kate County.
Same from my side, Judge.
Anything on the 6th? Friday the 6th?
For either.
How about Friday, September 6th? I understand that's preceding your trials, but I have that day open if it works.
I could make that work, Judge.
Works well for me, sir.
That's fine, me, Ron.
Okay. Morning or afternoon setting, does it matter?
Doesn't matter to me.
No position from me, Judge. 9:30 would be great, but whatever those guys like, it's fine with me.
Morning is fine with me, Your Honor.
September 6th at 9:30 for preliminary examination in both matters. Any and all bonds continue, conditions of the bonds continue. They're ordered to appear in person with their counsel Friday, September 6th at 9:30.
Thank you, Your Honor.
Anything
Thank you,
else?
sir.
Cases from counsel?
Not on behalf of the state, sir. Thank you.
No, Your Honor.
No, Your Honor. Thank you.
Appreciate your appearances and patience.
Yes, sir.
Thank you.
I didn't see Mr. Deffenbaugh on my policy or
Oh,
committee.
he has that paper.
Okay. Mr. Deffenbaugh. This is another commitment setting. Anyway, sir, you're in the custody of the Sumner County Sheriff pursuant to an arrest yesterday evening. The allegation is a violation of a protection order. Affidavit would suggest that you made contact with a person that was under protection. Sumner County case 2024 DM 169. I've looked at that case a little bit. I was not the judge, or am not the judge that reviewed the petition or entered the temporary orders. I am aware of an order that allowed you to go to the residence and pick up your personal clothing and effects, though I don't understand if that was to an Argonia residence or a Belle Plaine residence. So I've reviewed the PC affidavit. I find probable cause based on the PC affidavit. I've not set bond yet. Mr. Marcinski, are you aware of any of the events, either the PFA or I saw Mr. Deffenbaugh on a commitment 2 days ago, I think, and now today?
I can tell you that I have been reviewing the commitment from 2 days ago. At least anticipate filing some charges there. I don't know if as requested, but I do think that there's probably something there. I saw that there was a new commitment, or I'm sorry, a new referral in my charging queue this morning when I came in, but we've been hammered in docket all day, so I honestly haven't even opened it yet. I don't know what the allegation is, but you said it's a PFA violation, so I presume obviously that that's what it is, but I haven't even reviewed that case whatsoever yet, Judge, so I don't know.
It's the allegations, at least a violation of the PFA. I set a bond and I had some no contact on there with victims and witnesses, but I'm not sure if that, I think it's a minor or a youth. I'm not sure if he's both part of the PFA and my bond conditions or not, but Mr. Deffenbaugh, I'm not sure where that leaves you or where you can stay. Can you stay somewhere else than where the events happened in Argonia and these in Belle Plaine?
Sir, I was on my way to Anthony to stay with my mom. While we were backing out of the driveway when we got pulled over.
Okay.
But that's where I was on my way, Wellington, or not Wellington, but Anthony.
Okay. So I guess Mr. Marcinski, to the extent you know and have a position on bond, do you know what that would look like? I think it's posted 25,000 on the one of the commitment. I saw him. I think it's a attempted ag assault or something like that. With mother of the children, but not, I don't think she's your spouse. But something like that.
All right. Well, I'm sorry, Judge, 1 sec.
Yeah.
Judge, probably here's where I'm going to be at on that. It looks like Mr. Deffenbaugh has already posted a $25,000 professional surety bond in relation to the in relation to the case which was filed a few days ago. I don't see the case number in front of me, but this newest case, it does appear, alleges a PFA violation. Reports are very brief, so I don't have a lot to work off here. Honestly, I would probably be okay with like a $2,500 OR bond, considering he's already posted such a large amount of professional surety on the other case. It would appear to include all of the same victims and witnesses and everybody. So I would just ask that the conditions of the bond that are set forth in that case be attached to this case as well. But other than that, I based on the fact that he already has posted such a massive bond in the other case, I don't object to an OR bond in this case.
Mr. Defball, I agree with Mr. Marcinski, but you have to understand these conditions. Everything I've said previously applies. You have to follow the PFA. You have no contact, direct or indirect, with anybody from the Argonia issue. You'll have no contact with anybody, direct or indirect, from Belle Plaine issue, because I understand they may not be victims, but they may be witnesses. So if you bond on this case, you go to Anthony, as you indicated, stay with your mother, bury in, and don't push the issue. Do you understand all of that?
Yes, sir, I do.
Okay. We'll set bond amount of 2,500 OR, meaning you can sign that on your signature, but it will have all of those conditions. I'm going to write those on this commitment form. We'll get that to the jail. Be patient, and they'll process you out once they receive it. Your bond appearance date from your $25,000 bond will control. So your bond appearance should match, in this case, should match that case. So you'll have one court appearance for both cases.
And to be clear, Judge, just for the record, that is August 15th at 9 o'clock in the morning.
Thank you.
It's 15th. Now, also, you'll have the PFA trial. I'm just not making sure I'm not misleading you or overlooking it. You have a trial date on the PFA papers you were served. That's totally separate than what Mr. Marcinski and I are talking about. Okay.
That's August 5th.
August 5th is your trial date on that? Okay.
First appearance, I don't know this trial day.
That on in PFA matters, you are showing up for a trial on those settings.
Okay.
Be prepared to go on your PFA issue. All right, we'll see you again August 15th. I'll get the paperwork to the jail. Mr. Deffenbaugh, please do as we've discussed. Don't push the issue.
Yes, sir. Thank you.
Deputy, any other commitments that you knew about?
No, Your Honor.
Okay, thank you very much for your time.
Thank you, sir.
Mr. Sinski, all I had for this morning. Are you done?
Yes, sir. We'll see you at 110 with Mr. Favre. I think we might have a couple cases worked out, so hopefully we get something done.
We'll do it. Thank you, everybody, for attending. See you this afternoon. Favre, can you hear me?
Yes, Judge.
Mr. Marcinski, recording going. I first got 23 CR 300,029, State versus Lisa Wise. Counsel, your appearances.
Larry Marchinsky on behalf of the state, sir.
Joseph Favre on behalf of Miss Wise, who is present at Lisa's A3UW on the screen. Lisa, can you turn your camera on?
Yes, sir.
Thanks. Matters on for status conference today. Mr. Favre, what can we accomplish?
Judge, we have a plea wherein Ms. Wise will be pleading to a misdemeanor theft in this case, but I don't know that we have an amended information yet. Or, I'm not sure. Actually, hold on. Is this the one we don't need one? I may be mixing this up. Yeah, we do. We do need one. So we need an amended information. We don't have one just yet.
Mr. Marcinski, when can we expect that, and what's our next setting?
Judge, I apologize. Looking at me and Mr. Favre's communications, I failed to notice that. I can have it done in as little as be ready by next Thursday, I'm sure.
Mr. Favre, July 25th at 1:10, 1:15, 1:10. You're muted, Joe.
Oh, I apologize, Judge. That's fine.
July 25th at 1:10. Ms. Wise, your bond will continue. Conditions of your bond continue. Order to stand in contact with Mr. Favre. Order to appear in person or by Zoom, July 25th at 1, to call it 1 o'clock, 1:10. You have any questions?
No, sir.
Thank you for your appearance.
Thank you.
Uh, 2023 CR 300,063, 2024 CR 12, 2024 CR 13, all the state of Kansas versus Constance Stoll. Counsel, your appearances.
Larry Marchinsky on behalf of the state.
Joseph Favre on behalf of Ms. Stoll, who is in the Sumner County Jail.
All three show for status conference. Mr. Favre, what can we do?
So, Judge, at this case, we have been negotiating a plea. Mr. Marchinsky did send me the information, the amended on that. It's slightly different than what we had discussed, but it's not. I think I may have made a mistake in what I sent to him. So I think we just need one more week to sort it out, and we'll be ready to go. So,
Mr. Marcinski.
I apologize to Joe and Ms. Stoll on the late me getting the complaint done. I don't have any objection. There is a little bit of difference between what we had talked about, so I know we need to discuss that. So no objection at all, Judge.
All three cases to July 25th at 1:10. Any bond amounts remain the same. If she's in custody, jail will have them available. If she makes bond, she's ordered to appear July 25th at 1:10.
Thank you.
Thank you. Any other cases for you, Mr. Favre?
I think that's it for me today, Judge.
Okay, appreciate your appearance.
Thank you, Judge.
Served by the Samsung SM device. Your name?
You're talking to me, Judge?
Yes, sir.
Jeremy Stewart.
He's set for sentencing with Mr. Pate whenever we take up those cases.
Okay, we got you for 1:30. Just be patient with us, sir, and we'll start that here shortly.
All right, thank you, sir.
Thank you.
Could I get a quick breakout room with Larry? Judge, I hate to slow things down, but I think we can knock out a lot of cases on Mr. King if I can get a quick breakout room with him.
Mr. Pate, your client's in custody? Oops.
That's correct, Your Honor. It's Mr. King sitting in the jail seat right now.
Okay, I've opened that second breakout room. They look both frozen, so yeah, they joined. Okay, very good. Don't see Mr. Hamey on 23 CR 152. Larry, do you know what's going on?
It's not going to be contested, Your Honor. Mr. Hamid reached out to the court earlier this week to advise he was going to be gone on vacation. He and I had a conference. He advised he wasn't going to object to my motion to endorse additional witnesses. The state will be submitting an order to that effect later today. And that matter is scheduled for jury trial on the 13th, I think.
Right.
Scheduled for jury trial on the 13th, and it is the prime case anticipated to go.
Very good. State's motion to endorse those witnesses is granted. File the appropriate order or journal entry. And we'll see everybody on that case for trial, jury trial as scheduled. Mm-hmm.
Hi, can you hear me? Can you
Yes,
hear me?
yes, sir.
Okay.
And
I'm
what's
about to start by Robert Nichols.
okay, Mr. Nichols, just be patient. We'll get to your case here shortly.
Thank you.
Yes, sir. Mr. Pate, what case you want to start with?
Well, we've got Mr. King in the jail, and if we can resolve that, that'll knock out like 2/3 of the docket.
We can do that. King, we have 2022 CR 165, 2024 CR 34, 2024 CR 93, all the state of Kansas versus James King, Larry Marcinski for the state, Chris Pate with the defendant who appears in custody.
You
Mr.
should
Pate.
also, I'm sorry, Judge. We should also have a 97, 24 CR 97. There's a total of 4 cases with Mr. King today.
You're right, and I have it, and I failed to add that. Appearances remain the same on that case. Mr. Pate.
Your Honor, we've got a resolution on all of these cases. In 22 CR 165, Mr. King would admit that he is in violation of his probation. Joint recommendation for a 30-day jail sanction and reinstate probation. In 24 CR 34, Mr. King would plead guilty to the sole count of interference with law enforcement, Class A misdemeanor. Recommendation of a 30-day jail sanction consecutive to 22 CR 165. And Larry, I believe you said 6-month underlying jail on that, or was I mistaken?
I think we had just talked about the sanction, just call that the underlying sentence, get him back on probation.
And I'm sorry, I froze up a little bit there, Larry.
I was just going to recommend the 30 days as the underlying sentence and let that case get done.
Okay. So 30-day jail sentence on 24 CR 34, that case would be recommended to be closed. 24 CR 93, a plea of guilty to count 1, violation of PFA, Class A misdemeanor. Recommendation that Mr. King be placed on probation in that matter. I don't think we discussed a specific underlying sentence, so parties would be free to make recommendations. Dismiss counts 2 and 3 in that matter. Dismiss 24 CR 97 in its entirety pursuant to the plea agreement. And then there was a apparently new case presented to Mr. Marcinski for a alleged offender registration violation. The state would agree to not file that as part of the plea agreement. And then the state would be recommending probation on 24 CR 93.
Okay. I think I've got all that. Mr. Marcinski, is that your understanding?
That is the agreement, sir. Yes, thank you.
All right. Mr. King, can you hear me okay?
Yes, Your Honor, I can.
All right. As to 22 CR, sorry, 22 CR 165. What is it? Where does it put the CR 97s?
No, okay, so go up to that gray box.
Yes.
Right there, yeah, you can choose which one. You usually hold it to the top. You can just scroll down.
Yes.
Nope, on the where you were on your documents. Yep, and then it'll break it up into cases.
Okay. On 22 CR 65, motion to revoke probation, supporting affidavit, supplemental affidavits anticipated you're going to admit to violating probation as alleged in the motion to revoke and the supplemental. Is that correct?
Yes, Your Honor.
Mr. Marcinski, am I working off of all the affidavits or just the most recent?
Judge, our agreement was that he was going to stipulate to the commission of a new crime and running from Deputy Mike Brown. I have to be honest, I didn't review all of the supplementals, so if there's any additional supplements, what we're proceeding on today is him interfering with law enforcement.
Okay. So that'd be the supplemental affidavit filed February 1st earlier this year. Mr. King got certain rights for probation violation process. You have a right to contest the allegations at a hearing in open court. Basically, that means we could have a trial. It's the state's burden to establish a violation of your probation by a preponderance of the evidence. You have a right to have an attorney represent you, this being Mr. Pate, at that hearing or trial. You have the right to present testimony of witnesses and other evidence in the defense of the allegations. If a violation of your probation is established, either because you admit to the violations today or because the state proves that at the hearing, this court then has the authority to continue, extend, or revoke your probation and could require you to serve the underlying sentence of incarceration. Do you understand all of those rights?
Yes, I do, Your Honor.
You understand the condition of probation that the state says you violated. I'm going to ask you if you admit or deny that you committed the crime of interference with law enforcement as alleged in 24 CR 34.
I admit it, yes, Your Honor.
You understand all the possible, before I ask you that, do you understand all the possible consequences of admitting to or stipulating to or otherwise being found in violation of probation?
Yes, Your Honor, I do.
Are you waiving your rights to the probation violation process in those hearings?
Yes, Your Honor, I am.
The allegations set forth in the motion to revoke and the supplemental as outlined from February 1st. Sir, do you admit or deny that on or about the 30th day of January 2024, in Sumner County, Kansas, you did commit the crime of interference with law enforcement as reflected in Sumner County Case 2024 CR 34?
Yes, Your Honor, I do.
Okay. I find you have knowingly, willingly, and voluntarily waived your rights to the probation violation process. Court finds that you understand the potential consequences of waiving those rights, admitting to the violations. Court accepts the defendant's admission and stipulation, finds he has violated probation as alleged in the motion to revoke as supplemented on February 1st. Got those recommendations. Any further recommendations from the state?
I don't think so, Judge, unless there need clarification on what we've discussed. The state is going to recommend the court impose a 30-day jail sanction as a sanction for the violation. Obviously, in regards to these misdemeanor cases, as we work through these, the state's going to recommend a sanction on those. I would acknowledge that Mr. King has been in custody for a fairly significant period of time now. I imagine he's probably served both of those sanctions at this period of time. But essentially, the state is asking that the court reinstate Mr. King's probation for another period of 12 months. We're going to work through some of these cases. The state's going to have some special conditions regarding contact and perhaps a drug and alcohol evaluation. But in regards specifically to this, the state is asking that the court impose a 30-day jail sanction, give Mr. King credit for time that he has served towards that sanction, being in custody. I could look it up. I'm sure Mr. King can advise us, but I think he's been in custody for 2 or 3 months now.
71 days, Your Honor.
And that's it, unless you have any questions, sir.
Mr. Pate, recommend any other record on the recommendations?
I just join in the recommendations already made, Your Honor.
All right, Mr. King, anything you'd like to say in mitigation of punishment or disposition? You're not required to say anything to this, your opportunity if you wish.
Just humbly admit that I was in the wrong and I'm willing to, make it right now. Thank you, Your Honor.
All right, appreciate it. We'll follow the recommendations. As I understand it, Mr. King, you'll be sentenced to a 30-day jail sanction. Give it credit for any time served towards that 30 days. The way I understand it, that has been exhausted. Your probation will be extended for a period of 12 months from today with the same terms and conditions. Upon your release from custody, you are to report to court services. Is he community corrections all overall or court services?
I believe he's on with court services, sir.
Report to Mr. Hollis at court services immediately upon your release from custody and as we go through these cases. Do you understand?
Yes, Your Honor, I do.
All right. 24 CR 34. Sir, it's anticipated you're going to enter a guilty plea to a Class A misdemeanor interference with law enforcement. Is that correct?
Yes, Your Honor, it is.
That would be the sole count of the complaint. How would I see 93 if I wanted to do them at the same time? CR 93. And so at the same time, sir, we're going to take up 24 CR 93, and that's the other case where it's anticipated you're going to enter a guilty plea to count 1 violation of a PFA, also a Class A misdemeanor. Is that in fact what you'd like to do?
Yes, Your Honor, it is.
In both cases, sir, I'm going to explain rights, and it applies to your knowledge and your understanding for both of those cases. Do you understand that?
Yes, Your Honor.
If at any point you have a question or want me to repeat what I'm saying, let me know and I will do that. Okay.
Okay, no problem.
Are you currently under the influence of any alcohol or illegal narcotics?
No, Your Honor, I'm not.
You currently take any medication or supplement that may affect your ability to comprehend and understand what we're doing today?
No, I'm not.
You understand in both cases you have a right to a trial by jury?
Yes, Your Honor, I do.
You understand that to be found guilty on misdemeanors, a 6-person jury would have to unanimously agree that you're guilty of these crimes?
Yes, Your Honor.
You understand that at that trial, the state of Kansas must prove your guilt beyond a reasonable doubt and that you're not required to prove anything, including your innocence?
I do, Your Honor.
You understand you maintain a right not to incriminate yourself and a right not to testify at any trial?
Yes, Your Honor.
You understand that at the jury trial, the state of Kansas has to bring in witnesses to testify against you in open court, that you'll be able to observe that you and Mr. Pate would be able to cross-examine the state's witnesses?
I do.
You understand you have the right to use the power of subpoena to find and compel the appearance of witnesses to testify in your defense of the allegations?
Yes, Your Honor, I do.
You understand you're not required to plead guilty today?
Yes.
You understand if you plead guilty today, you basically agree and admit that you've done what the state of Kansas alleges you've done in the CR 34 and count 1 of CR 93.
Yes, Your Honor, I do.
You understand if you plead guilty today to those counts, we'll not have trial on any of these issues?
Yes, Your Honor.
You understand if you plead guilty and we do not have a trial, your ability to appeal trial errors does not exist?
Yes, Your Honor.
Have any questions about those rights?
No, I understand fully.
Is it your desire to give up your constitutional rights to a jury trial and in your pleas today?
Yes, Your Honor, I do.
Left hand is 93.
Left hand is 93, so that's 97.
You want 34?
97 is being dismissed, I thought. Yeah, I think it's good. Yeah, I'm all right. Okay, sir, to the sole count of Sumner County Case 2024 CR 34, alleging a violation of KSA 21-5904A3, interference with law enforcement occurring on or about the 30th day of January 2024 in Sumner County, Kansas. How do you wish to plead?
Guilty, Your Honor.
And in Sumner County Case 2024 CR 93, to the charge made in count 1, alleging a violation of KSA 21-5924A1, violation of a protection order occurring on or about the 29th day of March 2024 in Sumner County, Kansas. How do you wish to plead?
Guilty, Your Honor.
Mr. Marcinski, brief factual basis.
Yes, Your Honor. In regards to 24 CR 34, the allegation of interference, should that matter proceed to trial, the state's evidence would have been that on or about January 30th this year, 2024, here at the Sumner County Courthouse here in Wellington, Sumner County, Kansas, that Mr. King had reported to the probation department as ordered. He was advised by Sumner County law enforcement, specifically Deputy Trillo, that CSO Hollis was going to file an A&D. They advised Mr. King he needed to sit tight as that paperwork went through, and they advised him that it was their intent to arrest him in regards to that PV A&D. Upon being advised that, Mr. King then fled from the courthouse, requiring a foot chase by deputies. He ran for a couple of blocks before he finally did drop to his knees and was able to be taken into custody. So in regards to the interference, it would be interfering with a properly licensed uniformed deputy, that being Deputy Victor Trillo and Deputy Daniel Michael Brown, and that they were lawfully, as part of their job duty, trying to arrest him in response to the A&D, and that he fled from them, requiring a foot chase, which would be the evidence of the interference, resisting arrest. In regards to case number 24 CR 93, it would be the state's evidence in that case that on or about March 29th of 2024, that Wellington police officers were dispatched to an address here in Wellington, Sumner County, Kansas, in report of a PFA violation. The caller on that was Miss Lindsay Stone, who had a PFA against Mr. Stone, Mr. King. That PFA being Sumner County case number 23 DM 188, which protected Miss Stone, her residence, work, and any other property. It's alleged that on that date, March 29th, that Mr. King went to Miss Stone's address. Mr. King arrived at the address and opened an unlocked door. He then leaned inside the residence and yelled into the residence for Lindsay Stone to come outside and talk with him. Stone, her children, and her grandmother all heard the commotion. She then called the police and Mr. King fled from the residence. So the state's evidence in that case would be that there was a lawfully imposed PFA protecting Miss Stone from Mr. King, and that on that day he went to the residence where Miss Stone was staying and attempted to make contact. He went in the door or opened the door and started speaking to her. The state's position would be that that would be a violation of the no contact order set forth in that PFA. So that would be the state's evidence in regards to that case as well.
Thank you. Mr. King, do you agree that the state of Kansas has evidence to prove you guilty of these two crimes if we had jury trial?
Yes, Your Honor, I do.
Are you pleading guilty today because you are in fact guilty?
Yes, Your Honor, I am.
We'll accept your guilty pleas, find you have voluntarily, knowingly, and intelligently waived your constitutional rights to enter your guilty pleas today. Court finds factual basis for your guilty pleas and further finds you understand the nature of the charges, consequences of your guilty pleas. As such, court will find James King guilty in the sole count of 2024 CR 34 and count one of Sumner County case 2024 CR 93. Pursuant to plea agreement, the court dismisses the remaining counts of 2024 CR 93 and 2024 CR 97 in its entirety. Sentencing, Mr. Marcinski, can we do that today? Do you need to notify any potential victims or victims as alleged?
I can tell you it was the anticipation of the parties that we would proceed to sentencing today, Judge. I would advise the court. I sent Ms. Stone a letter on June 20th advising her of today's court date. I don't see Ms. Stone in the courtroom. I haven't had any contact with her personally since we spoke several months ago. So it would be my position. We've at least tried to, yeah, we did send her a letter advising her of the time and date of this hearing. So I do believe we've complied with the Victim Bill of Rights in regards to 24 CR 93. And the state of Kansas is the victim in 34. So there's no Victim Bill of Rights appropriate or applicable there.
Thank you. Any further recommendations from the state?
Just to be clear, Judge, the state is asking the court to consider imposing as a punishment in 24 CR 34, the interference with law enforcement, a 30-day jail sentence. The state's going to ask that that 30-day jail sentence be run consecutive to the PV sanction in 22 CR 165. That being said, I still believe that Mr. King has more than likely exhausted that time awaiting disposition on these cases. In regards to 24 CR 93, the state's requesting the court consider imposing a 12-month underlying sentence, suspending that sentence to probation with court services. At this time, the only conditions that the state is asking for in regards to that would be to have no contact with Ms. Stone. It is my belief, I'm running a little behind today, but it is my belief that that PFA is still in effect. So I'm just asking that he have no contact with her pursuant to that. And then I had mentioned some drug and alcohol, but I've been reviewing these cases as we've been going through it, and I don't see any allegations that Mr. King was inebriated. So I don't know that it would be appropriate for me to request drug and alcohol treatment at that time unless I guess I would ask for the court service officer to be allowed to request that if they believe it's appropriate as they're supervising him. But And to be clear, I am essentially asking that each one of these cases run consecutively to the one prior to it. They're 3 or 4 different separate incidences, so I think that the underlying sentences should most appropriately be run consecutively. But of course, any probation periods would run concurrent by operation of law. I'm not requesting any fines. I think that's all I have, Judge.
Thank you. Mr. Pate?
Your Honor, I think the sentencing recommendations are generally appropriate. I do believe, I think the PFA may be dismissed if I understand right, but I've not independently confirmed that. I think if Ms. Stone wishes contact and wants to advise probation of that, then maybe at that point it would be appropriate, but otherwise I would defer to the court.
Mr. King, you have the right to allocution. You have the right to say or present any evidence you have in mitigation of punishment. You're not required to say anything, but this is your opportunity if you wish.
No, Your Honor, I am in agreement with everything that's going on. Thank you.
Okay. All right. See, 22 CR 34 will be the order and judgment of this court that James King serve 30 days in the Sumner County Jail. Those 30 days to be consecutive to 2022 CR 165. He's to be given credit for any time spent incarcerated during the pendency of that case, applicable to that case. Mr. Marcinski, you are not asking for court costs, booking fee, or attorney's fees. Is that correct? As part of that one?
Judge, I didn't negotiate for those things. I never do. I mean, typically we just agree that he would pay any appropriate costs or fees. I didn't make any plea negotiations or make any agreements in regards to any of those financial things. So I would defer to the court on that.
Understood. There's no probation in that case, and it's just straight jail sentence. I'll waive court costs, I'll waive a booking fee, and I'll waive his reimbursement of that attorney's fees in CR 34, though Mr. Pate to still submit for full reimbursement. In 2024 CR 93, it'll be the order and judgment of this court that Mr. King be sentenced to 12 months in the Sumner County Jail, that to be suspended, credit for any time served that's applicable to that case. That jail sentence is consecutive to 2022 CR 165, 2024 CR 34. Suspend that 12 months, go on 12 months of probation with court services. That runs concurrent to 2022 CR 165 for probation purposes. Mr. King will pay court costs, a booking fee, probation fee, and reimburse the cost of his court-appointed attorney for that case. Special condition of probation, he'll comply with any protective orders. I won't get into the no contact as part of this probation. If there's a case out there, apparently she knows how to do that and how to address that. If it's no longer active, then he's free to have that contact. And again, 2024 CR 97 is dismissed in its entirety pursuant to the plea agreement in the other 2024 cases.
Thank you.
Yes, sir. Mr. Marcinski, Mr. Pate, did I cover all 4 matters appropriately? Did I leave out anything?
Judge, the only thing that Chris and I have agreed to is at this time the state is LOPing. Let me find the case number. Sumner County Sheriff's Office incident number 24-1034. Essentially, I would say that I'm dismissing or I'm LOPing it without prejudice on the idea that Chris has done a great job advocating for Mr. King. I think Mr. King's at a good spot right now. However, if the criminality reemerges, I may reconsider the LOP of that case at this time. But in order to resolve the cases today, the state has agreed to, at this time, LOP Sumner County Sheriff's Office 24-1034, which alleges a violation of the Kansas Offender Registration Act.
Okay. Make that part of the record in the journal entries. I understand that to be you're not filing in at this time, and if he goes, I assume makes a probation period without further violations of law, it'll not come back. But you have that option if it does.
Yes.
Got it. Mr. Page, is that sufficient?
Yes, Your Honor.
All right, Mr. King. All that'll be reduced to writing. 1 or more agencies need to tally up how much credit for time served, assuming you've served the 30-day jail sanction in 22 CR 165 and the 30-day jail sanction in 24 CR 34. It would appear you could be released to probation, and again, immediately upon release, report to court services.
I'm right down there, Your Honor.
Ma'am, at the podium, were you here for this case?
Yes, Judge. My name is Kimberly Wells. I'm Jimmy's mother.
Okay.
How would we get his probation transferred to Wilson County? He's wishing to come out to Neodesha where we live to start over out there.
Okay. I will certainly authorize that if Wilson County will supervise. Candidly, that's a conversation between our local court service office and the one in Wilson County. If they will accept supervision as courtesy, that's authorized.
Thank you so much.
Yes, ma'am. Mr. King, you need to have a conversation with Mr. Pate, stay in his good graces. You need to sign up for court services here and stay in their good graces. Unless and until they tell you, you can move to Wilson County and your probation will be transferred. Do you have any questions?
No, Your Honor. I thank everybody for what we've been through, and I'm willing to move forward and make this right.
Take you at your word. Please do that. And I wish you the best of luck doing that. Mr. Pate, anything else on these cases?
Not at this time, Your Honor.
All right. Mr. Marcinski?
No, Your Honor. Thank you.
All right. Mr. King, be patient. We'll get documentation to the jail for their purposes.
Yes, Your Honor. No worries.
Mr. Pate, your next case?
I think we've got Mr. Elliott at the jail for a sentencing.
All right. I've got 2024 CR 104, 2024 CR 68, both the state of Kansas versus Jeremiah Elliott. Counsel, your appearances.
Larry Marchinsky on behalf of the state.
Your Honor, Chris Pate on behalf of Mr. Elliott, who appears in custody at the jail.
Thank you. Both show for sentencing today. Let's see, are these 2024 CR 68 is a felony sentencing in 104. The misdemeanor sentencing, is that correct?
Yes, Your Honor.
Yes, Your Honor.
All right. No motion for departure. Mr. Marcinski, if applicable, have the provisions of the Victims' Rights Amendment to the Kansas Constitution been complied with?
Judge, that's a quick question. Give me one moment. Judge, I do show that we have sent the alleged victim in this case is who I'll refer to as Baby Elliott. But we have sent letters to Baby Elliott's mother, and most recently as June 20th, advising her of today's date. I don't see that I've had any responses from that young woman, and I don't see anybody in the courtroom or anybody that I recognize. So the state's record would be that we have sent letters to the victim advising her of today's date and giving her an opportunity to submit a victim impact statement, which it does not appear that I have received. So yes, the state has done everything it can to comply with the Victim Bill of Rights.
All right. Anybody in the South courtroom here for this case?
No, sir.
Okay. See, Mr. Elliott appeared before the court June 20th earlier this year, entered pleas to count one of the complaint in 24 CR 68. Court accepted his plea, found factual basis for his plea, found him guilty of that crime, ordered pre-sentence investigation to be completed. That was filed with the court July 9th. Have the parties had sufficient opportunity to review the pre-sentence investigation?
The state has, sir.
I have, Your Honor.
Does either party have any disagreement with the criminal history worksheet contained in the PSI?
State has no objection, sir.
Defense has no objection to criminal history of I.
Mr. Elliott, do you agree and admit that the criminal history set forth in the worksheet is true and correct to the best of your knowledge? And I will tell you, it just shows a prior conviction for misdemeanor battery.
Yes, sir. Yes, sir.
All right, the court will find that the defendant's criminal history score for the primary offense is I. Primary offense is aggravated battery as shown in KSA 21-5413B2. That is a severity level 5, person felony. The presumptive guideline sentence for the primary offense is a minimum prison term of 31 months to a maximum of 34 months, with 32 months being the mid-range sentence. There's a recommended post-release supervision duration of 24 months and a possible probation duration of 36 months. The felony sentence is a border box sentence. Does anybody have any disagreement with those findings?
No disagreement on behalf of the state of Kansas, sir.
No, Your Honor.
On 24 CR 68. Oops. I'm sorry. On 24 CR 104. Mr. Elliott has been found guilty of misdemeanor battery violation of KSA 21-5413A1 Class B person misdemeanor. Mr. Marcinski, what are the recommendations from the state on both cases?
Yes, Your Honor, thank you. It may be easier to work backwards. The battery case, which we've discussed, 24-104, that's a battery that occurred in the jail a month or so ago. The state is recommending in that case just a 30-day underlying jail sentence, not requesting probation, just have Mr. Elliott serve a 30-day jail sanction for that battery. I believe he's more than served that. I advised Chris that I was going to recommend the court give him credit for time served. Then backing up or going in reverse order, looking at the felony case 24 CR 68, the state has agreed with Mr. Pate and Mr. Elliott that I would join them in border box findings. Ask the court to consider granting Mr. Elliott probation pursuant to border box findings as opposed to the optional jail sentence that the court could impose. I am asking if the court does decide to make border box findings. The reason that I've agreed to that is that I do believe that there are anger management therapies available here locally in the community or in Sedgwick County. And the state is asking that if the court does make border box findings, that he order as a condition of probation that Mr. Elliott attend anger management or whatever therapies are appropriate. In regards to the disposition here, Judge, again, I have advised Mr. Pate that I would agree to the court making border box findings. As such, I would ask the court to consider placing Mr. Elliott on probation with community corrections, that the court impose all of the appropriate conditions as set forth in the PSI. I would also ask the court to impose all of the applicable fees, including the $400 Child Advocacy Center fee. I would very candorously admit to the court that Chris and I didn't discuss the CAC fee because I frequently forget them. But it is, I believe it would be appropriate to impose it here unless, of course, the defendant makes a workability issue. At this time, I did advise Mr. Pate that as part of my recommendations that the court consider imposing border box, I am asking that the court also impose no contact with baby Elliott until those anger management provisions have been met with. So that might be difficult for community corrections to keep track of. I'm not ultimately wanting to keep Mr. Elliott away from his child, but I do want to see that he gets into anger management and works through some therapies first. So I did advise in my written plea agreement that I was going to ask for no contact until those therapies had occurred. And that, I believe, is the sum total of my recommendations, Your Honor. I'm not requesting any fines. Again, in review of the file, I did send victim impact statements and other forms to the alleged victim's mother here. None of those have been returned to me. So I don't have any other thing to discuss outside of what I've already said.
Thank you. Mr. Pate, recommendations on behalf of the defendant.
Your Honor, I I agree with the recommendations and I'll work backwards as well. 24 CR 104, the battery, 30 days credit for time served and close the case. And I think one of the reasons that's appropriate, and would ask that that case not be so much held against Mr. Elliott in the felony sentencing. This was a fight that occurred in the jail. The individual that got in the fight with Mr. Elliott is an individual that I believe is being held on murder charges. He actually instigated a fight with Mr. Elliott, was calling him all sorts of racist names, came up to Mr. Elliott and started pushing him. And then Mr. Elliott fought back and defended himself. Ultimately, Mr. Elliott won the fight and then didn't stop. And that's why it got charged. But it started out as a self-defense issue. And I just, not trying to avoid responsibility, I just want the court to be aware of that. In the felony case, we would ask the court follow the plea agreement, make the border box findings, impose the mid number of 32 as an underlying sentence. We think border box findings are appropriate, specifically, as Mr. Marchinsky said, that appropriate treatment programs are readily available in the community and that Mr. Elliott can be admitted within a reasonable amount of time. There are an abundance of parenting classes and anger management programs that would be available for Mr. Elliott to get in right away. He's also only 22 years old. He has no criminal history whatsoever other than the two cases we're here on today. While this is a very serious case, there's no instances of Mr. Elliott committing any acts of violence against anybody other than the individual at the jail that attacked him and obviously the victim in the felony case. So we think community safety interests can be protected. We think border box findings can be made. We would ask the court adopt those, place Mr. Elliott on probation for 36 months with community corrections.
All right, Mr. Elliott, do you wish to make a statement on your own behalf or present any evidence in mitigation of punishment? You're not required to say anything, but this is your opportunity if you wish.
Yes, I just want to say that I appreciate everybody, Mary Marchinsky, Chris Pate. I don't know if I can say this or not, but I am grateful. In the beginning years, I thought that I would be sitting here, and I'm just trying to be a father. It's pretty much it. I just don't want my kids to grow up like me, or I don't want my sons to go down the road as me, because my father was never there for me. So I want to make sure my kids get the best of the world. I just need help learning to be a better father, to be a better parent. Heard from a lot of people who say that parents, it's not easy being a father. So I'm willing to take parenting classes, anger management classes, because sometimes I do get angry. And I just want to apologize to the individual out there that I got to fight with. I treat everyone as human. I don't see people different from anybody. I see human as the same blood, the same color. And I do want to say, if the guy out there that got to fight with me is wanting me to forgive him, I do forgive you, and I'm sorry as well. I hope that one day we can all just come together as one. And yeah, that's pretty much it, Your Honor. Thank you.
Thank you. All right. Does either party know of any reason, legal or otherwise, why a sentence should not be imposed at this time?
State knows none, sir.
No, Your Honor.
Mr. Elliott, do you know of any reason why a sentence should not be imposed at this time? I didn't hear you. I'm sorry.
I'm sorry, what you say?
Mr. Elliott, do you know of any reason why a sentence should not be imposed at this time?
No, I do not.
For 24 CR 104, be the order and judgment of this court. Jeremiah Elliott serve a 30 days in the Suffolk County Jail. That time to be served, him to be given credit for any time spent incarcerated during the pendency of that case. based on the circumstances, underlying facts, and his what will be a financial obligation in 24 CR 68. The court will waive all costs of 24 CR 104. For 24 CR 68 will be the order and judgment of this court that Jeremiah Elliott be sentenced to serve a term of 32 months in the Department of Corrections. That is the mid-range sentence. This sentence will carry a post-release supervision duration of 24 months, and Mr. Elliott may earn up to 15% good time credit towards this sentence. Needs to be given any time spent, credit for any time spent incarcerated during the pendency of this case. It's occurring as we speak. PSI reflects to be determined, but I assure you, Mr. Elliott, that will be calculated correctly. If you have any questions about that, please speak to Mr. Pate and get that back before the court for determination. The court will find an appropriate treatment program exists, which is likely to be more effective than the presumptive prison term in reducing the risk of offender recidivism, and the recommended treatment program is available, and the offender admitted to the program within a reasonable amount of time. As such, the court will suspend the 32 months in the Department of Corrections, suspend that sentence, make it underlying to supervised probation with community corrections for a period of 36 months. Court authorizes the supervising agency to utilize immediate sanctions allowed under KSA 223716. Mr. Elliott, you'll be placed on probation under the standard terms of probation found in Kansas statutes. Further, you'll abide by any special conditions contained in the PSI. Are you familiar with what this PSI says?
Is it iBox?
Well, I'm sorry, for special terms of probation, there are things in the PSI that are not included in Kansas statutes, so thereby they are special, such as you'll be subject to travel and curfew restrictions. You'll submit to testing of breath, blood, or urinalysis at your request. I'm sorry, at your expense at the request of community corrections. You'll gain and maintain employment. The court will order you to complete anger management counseling. You will complete parenting classes. And then I'm going to give the discretion to community corrections that if there's some domestic violence type treatment classes, anything like that, that you could benefit from, they have the discretion to require that as well. All that taken together with your word, I think that addresses issues that you've already recognized in yourself and for your family and gets you back on the right track. Do you accept probation on all of those terms? Court will order all special conditions of probation reflected in the PSI and as outlined by the court should apply to Mr. Elliott's probation. In this case, Mr. Elliott will pay court costs in the amount of $193, a DNA database fee of $200 if he's not previously done so in his lifetime. He'll pay the probation fee of $120. He will pay the Children's Advocacy Center assessment fee of $400. He will pay the BIDS application fee of $100. And he will reimburse the cost of his court-appointed attorney. If I didn't say it, the booking fee of $45 will apply also. Again, I balance that with the waiver of all costs in 24 CR 104. And Mr. Elliott, you should have every reminder for the next 36 months of what you should do and what you should not do. And if that's making sure you have a payment to the court, I can't say I feel terrible about imposing all of these costs. So take that for what it's worth. Do what you say you'll do, and I'm sure you'll be successful on probation.
Thank you, Honor.
Mr. Marcinski, Mr. Pate, other than expungement and appellate rights, is there anything I failed to address?
My somewhat unusual request for no contact with baby Elliott until the anger management was done. That's the only other thing that I don't think the court has specifically addressed.
100%. No contact with the victim of 24 CR 68 unless and until you have that permission from your probation officer, and that will only be available to them after you complete all anger management and parenting classes, and they believe a domestic violence session or classes are not appropriate, and they say you can have contact. Does that make sense, Mr. Elliott?
It does.
Okay. Mr. Marcinski, anything else from the state?
No, thank you, sir. I appreciate it.
Mr. Pate?
No, Your Honor.
Mr. Elliott, you may have the right to expungement of these crimes under KSA 216614. That means after completion of your sentence or probation, and then after a period of time as required by statute, you may petition this court to seal or expunge your convictions. Do you understand your rights to expungement? Mr.
Yes, Your Honor, I do.
Mr. Elliott, you may appeal the sentence of this court if you believe it has been imposed illegally or contrary to law. If you wish to appeal, a notice of appeal must be filed within 14 days of today's date. Do you understand it's 14 calendar days, and that's a hard and fast rule? If in the event you wish to appeal, please let Mr. Pate know as soon as possible. I'll direct as his last act of trial counsel to file the notice of appeal on your behalf. In the event you appeal the sentence, and if you still qualify, an attorney could be appointed to represent you, and a transcript of the sentencing proceeding would be provided for your use at no charge. Mr. Elliott, do you understand your rights to appeal?
Yes, Your Honor, I do.
Mr. Elliott, you are a convicted felon. You've lost many civil liberties. Among those, you are prohibited from possessing firearms and various weapons found in Kansas statutes. Further, you've also lost the right to vote until your sentence has been fully discharged. Sir, do you have any questions about the sentence imposed or any other orders of the court you've heard today?
No, I don't.
Mr. Bruner, when should he report?
Hi, Mr. Elliott. My name is Mike Bruner. I'm going to be your PO. When you get released from the jail, they have my business card and contact info, in case you don't know where we're at. If you can get here by 5 p.m., come in today. If not, will you come in at 9 a.m. tomorrow morning?
Yes, sir, I will.
All right. Well, we'll see you then. Thank you.
Thank you. Have a good one. Thank you, Your Honor.
Mr. Elliott, good luck to you on probation.
Thank you.
Case was about what they said here. Is that 68, 68, 104, 104? Okay. All right, Mr. Pate, your next case.
Who do we have at the jail?
Mr. Harris.
That is Mr. Paw's case. Mr. Paw was requesting that just be continued 1 week because he was unavailable today.
All right, Mr. Marcinski, July 25th at 1:30.
No objection, sir. Thank you.
All right, that matter moved 2023 CR 167 to July 25th at 1:30.
You can just take a seat right there, Mr. Bailey.
Mr. Boyd?
Sir.
Your Honor, the next case we could take up, we have Robert Nichols on the box labeled Zoom user.
Okay, 2023 CR 195, State versus Robert Nichols. Zoom user got him. Counsel, your appearances.
Larry Marchinsky on behalf of the state of Kansas, sir.
Chris Pate on behalf of Robert Nichols appearing by Zoom.
Thank you. Shows kind of on a bond appearance, sort of modified bonds, last filing with the court July 3rd. Mr. Pate, what can we do today?
Your Honor, I would just request August 8th on that. I'm still getting up to speed reviewing the case and talking with the client.
Mr. Marcinski?
No objection, sir. Thank you.
All right, Mr. Nichols, your next court appearance will be August 8th at 1:30. You're ordered to appear in person or by Zoom. Your bond will continue. Any and all conditions of that bond will continue. Do you have any questions for today?
No, sir. I appreciate it. Thank you.
All right, appreciate your appearance. Appreciate your patience.
Yes, sir.
Mr. Pate, got, let's see, Mr. Moore and Mr. Stewart.
Is Mr. Moore present in the courtroom? On that, I'm going to be just requesting a continuance on that case, Your Honor.
All right, 23 CR 205, State versus William Moore. Marcinski for the state. Defendant. State, what's the
Your Honor, defense is requesting August 8th. I'm in plea negotiations with Mr. Marchinsky.
Mr. Marcinski?
No objection, sir. Thank you.
Mr. Moore, your next court appearance will be August 8th at 1:30. You're ordered to appear in person or by Zoom. Stay in contact with Mr. Pate. Conditions of bond and bond will continue. Do you have any questions? Feedback?
No.
All right, I'm sorry, Mr. Moore. I was hearing some other things. Do you have any questions for me, sir?
No, I still don't.
All right, I appreciate your appearance. And 2024 CR 14, State versus Jeremy Stewart. Counsel, your appearances.
Larry Marchinsky on behalf of the state.
Your Honor, Chris Pate on behalf of Jeremy Stewart. He appears via Zoom in the box that says Samsung.
Okay, Mr. Stewart, can you hear us?
Yes, I can. Can you hear me?
We can hear you also. Matter shows for sentencing today. PSI is filed with the court July 11th. There's a motion for downward departure filed on July 12th. Mr. Pate, do you require a special setting for the motion, or can that be taken up as part of sentence?
Your Honor, I anticipated arguing it today.
Okay.
Judge, I'm joining the defense in their departure request. I'd waive any notice requirements or anything like that. State's ready to proceed with sentencing today.
Very good. Thank you. Mr. Marcinski, if applicable, have the provisions of the Victims' Rights Amendment to the Kansas Constitution been complied with?
This is a registration violation. I don't typically send out notifications on that. One second, sir. I'm sorry. I wasn't prepared for that question.
I'm showing it as interference with law enforcement, at least in title.
It was originally charged as a registration violation pursuant to plea negotiations and the disposition we're trying to work out here. I amended it to interference with law enforcement for false report. To be honest, Judge, I did not send out any victim letters on this case, but it would be my position that either way, the state of Kansas would be the victim in this case. So the Victim Bill of Rights isn't applicable.
Sure. Mr. Stewart appeared before the court June 20th earlier this year, entered pleas to count 1 of the complaint, that being interference with law enforcement, violation of KSA 215904. Court accepted his plea, found factual basis for that plea, and found him guilty of that crime. Parties had sufficient opportunity to review the PSIs.
The state has, sir.
Defense has, Your Honor.
Does either party have any disagreement with the criminal history worksheet?
No objection or disagreement on behalf of the state of Kansas, sir.
No objection from the defense as to criminal history B.
Mr. Stewart, do you agree and admit that the criminal history set forth in the worksheet contained in the PSI is true and correct to the best of your knowledge?
Yes, I do, Your Honor.
All right, for the primary offense being count 1, court finds Mr. Stewart's criminal history score is B. Primary offense again is count 1, interference with law enforcement, violation of KSA 215904. It's a severity level 9, non-person felony. Court will find the presumptive guideline sentence for the primary offense is a minimum prison term of 13 months to a maximum of 15 months, with 14 months being the mid-range sentence. Sentence carry recommended post-release supervision duration of 12 months, possible probation duration of 12 months. This is a presumptive prison sentence. I show no special rules applying. Either party have any disagreement with those findings?
No, Your Honor.
No, Your Honor.
All right, Mr. Marcinski states recommendations regarding sentence and position on the motion for departure.
Thank you, Your Honor. As I briefly alluded to previously, the state has agreed to join Mr. Stewart in his request for a departure to probation. Chris did a good job drafting the motions. He set forth basically the substantial and compelling reasons that he and I discussed that would support a departure here. Primarily, the state looks at the fact that Mr. Stewart hasn't violated any registration or had any registration issues since 2007. This would, for all intents and purposes, appear to be the first time he's had a registration violation issue. The parties have also recognized the fact that Mr. Stewart is, for all intents and purposes, a resident of the state of Nebraska. The state doesn't object to him transferring his probation to Nebraska. Again, as part of working through this disposition, the state would note that Mr. Stewart did spend the better part of 5 months in custody awaiting a plea agreement here. And then Chris can correct me or not, but I believe he was bonded out after entering a plea. based on the parties' agreement for a dispositional departure to probation. So essentially, Judge, I am asking the court to consider imposing the standard number, that being 14 months. However, as I've already stated, I am agreeing or in coordination with the defense, asking the court to consider not imposing the prison sentence, but to depart to probation with community corrections. I would ask the court to impose any of the special conditions set forth in the PSI as a condition of that probation. I've already said it, but to be clear, I do not object to Mr. Stewart being allowed to transfer his community corrections probation to Nebraska. Again, I believe he is a resident of the state of Nebraska, and so has significant ties to that state. So I had no objection to him going back. And I think that that's all I have for your honor. Thank you.
Thank you. Mr. Pate, on behalf of the defendant.
Your Honor, I would ask the court adopt the findings in the motion for downward departure that I set forth and that Mr. Marchinsky joined in. I don't think I need to recite everything in there since it's already in the record in writing. I would also say Mr. Stewart he's back in Nebraska. He's gainfully employed up there. I don't recall where he works, but he is working up there. He's timely appeared. He's been very cooperative throughout this process. As Mr. Marchinsky said, didn't have any registration issues until all this came up. He'd been compliant for a long time. We'd asked the court give him 12 months probation on this with the 14-month standard sentence. He's served a significant amount of time in jail as we work towards resolution, which I think has served as a pretty good sanction. It's about a third of what the standard sentence would be.
Thank you. Mr. Stewart, if you wish to make a statement on your own behalf or present any evidence in mitigation of punishment, you're not required to say anything, but this is your opportunity if you wish.
Yes, Your Honor. All I want to say is, like I said, I lost my mom last year, February 22nd, and I was just going through a tough time and everything like that. And I just took time to really evaluate myself, and I know I needed to get back on track, and which I have. I work at Acuma. I've been working there for about 2 weeks, going on 3 weeks. Doing good out there, and I haven't missed a day of work or anything like that. I'm trying to be compliant with everything. So whatever is supposed today, I'll accept.
Okay, thank you. Does either party know of any reason, legal or otherwise, why a sentence should not be imposed at this time?
No reason known by the state, sir.
No, Your Honor.
Mr. Stewart, do you know of any reason why a sentence should not be imposed at this time?
No, Your Honor.
Sumner County case 2024 CR 14 will be the order and judgment of this court. That Jeremy Stewart be sentenced to serve a term of 14 months in the Department of Corrections. That is the mid-range sentence. Sentence will carry a post-release supervision duration of 12 months. He may earn up to 20% good time credit towards his sentence. Defendant is to be given credit for any time spent incarcerated during the pendency of this case. PSI would indicate at least 142 days. As to the motion for downward departure in dispositional fashion, the court will find substantial and compelling reasons exist to grant Mr. Stewart's request. A portion of those reasons are as cited in the motion, that he's taken responsibility for his actions, that he has served a significant amount of time in custody. And he has had no prior issues with registration or honoring his registration requirement before this matter. As such, court will suspend the prison term and place Mr. Stewart on supervised probation, that to be supervised by community corrections. Court will authorize the supervising agency to utilize immediate sanctions as allowed under KSA 223716. Mr. Stewart, you're being placed on probation under the standard terms of probation found in Kansas statutes. Further, you'll abide by any and all special conditions of probation that are shown in the PSI. Are you familiar with the PSI and what that requests?
Yes, I am, Your Honor.
Do you agree to follow all standard and special terms of probation as a grant of probation?
Yes, Your Honor.
Court orders all special conditions found in the PSI will apply to Mr. Stewart's probation. Mr. Stewart will pay court costs in the amount of $193. He will pay a DNA database fee of $200 if he's not previously done so in his lifetime. He'll pay a probation supervision fee of $120. He'll pay the booking fee of $45. He will pay the bid's application fee of $100, and he will also reimburse the cost of Mr. Pate's services, his bid's attorney's fees in full. We'll authorize the probation to be transferred to Nebraska if they will accept that. Mr. Pate, anything I've failed to address or anything I've overlooked other than expungement and appellate rights?
Not that I'm aware of, Your Honor.
Mr. Marcinski,
Thank you, sir. Nothing I see. I've got everything I need for my journal entry.
Mr. Macy, when and how would you like Mr. Stewart to meet with you and sign up?
Mr. Stewart, you have a pencil or pen that you can take down my number?
Give me 1 second, please. Okay, I'm ready.
So 620 326 8959. Just give me a call as soon as you log off the hearing.
Okay, I will do that.
Mr. Stewart, you may have the right to expungement of this crime under KSA 216614. That means after completion of your prison term or probation, and then after a period of time as required by statute, you may petition this court to seal or expunge the conviction. Do you understand your rights to expungement?
Yes, I do, Your Honor.
Mr. Stewart, you may appeal the sentence of this court if you believe it has been imposed illegally or contrary to law. If you wish to appeal, a notice of appeal must be filed within 14 days of today's date. That's a hard and fast rule. Do you understand 14 days, calendar days?
Yes, I do, Your Honor.
If you wish to appeal, please let Mr. Pate know as quickly as possible. I'll direct as his last act of trial counsel to file a notice of appeal on your behalf. In the event you wish to appeal, and if you still qualify, an attorney could be appointed to represent you, and a transcript of your sentencing hearing would be provided for your use at no charge. You understand your rights to appeal?
Yes, I do, Your Honor.
Mr. Stewart, you're a convicted felon. You've lost many civil liberties. As a convicted felon, you're prohibited from possessing firearms and various weapons found in Kansas statutes. Also, you have lost the right to vote until your sentence has been fully discharged. Do you have any questions about the sentence that's been imposed or any other orders of the court that you've heard today?
No, I don't, Your Honor.
You need to call Mr. Macy immediately after this hearing. Good luck to you on probation. Anything else from counsel on Mr. Stewart's case?
Nothing on behalf of the state of Kansas, sir. Thank you.
No, Your Honor.
All right, Mr. Stewart, appreciate your appearance. Again, good luck to you. You're excused from the hearing.
All right, thank you.
I believe that's all I have, Your Honor. Do you show anything else for me?
That's all I have for you and Mr. Paul. Thank you.
All right.
Good to see you.
Thank you. You too. Everybody have a good day.
Take care, Chris.
You too.
Judge, I apologize. We've been pushing hard since 1. Could we possibly take a 5-minute comfort break before we start taking up Austin's cases? And I'm sorry, Austin, you got to wait a few minutes.
It's fine with me, guys. Certainly can. I'll be in recess for 5 minutes.
Thank you, sir.
Gosh, dang it.
Larry, you might check your phone. I sent you a text. I didn't get it, Austin. Sorry. Oh, I just got it. Okay. Is he here?
Yep.
Okay, because he was actually summoned to come in at 9 o'clock this morning and he didn't appear. But I just asked Judge to set it aside till 2:30. There's a new case we'll need to do first appearance on, but I don't have any objection.
Okay.
We'll get the PSI straightened out.
Hi, I'm unmuted.
All right, Ms. Paulgraff, ready for your portion?
Ready as ever, Judge.
Your first client, please.
I'm Joe Jackson, Judge.
Like 2024 CR 17, 2024 TR 100, both state of Kansas versus Joseph Jackson. Counsel, your appearances.
Larry Marchinsky on behalf of the state.
Austin Paulsgraf representing Joseph Jackson appears in person and by and through counsel.
Thank you. Both matters show for sentencing today. Are the parties ready to proceed?
Judge, at this time, going through the PSI with my client, I'm noticing at least one, if not two, significant differences from what was actually pled to, which is causing a significant difference on the time that would be served in the underlying sentence. So no, Judge, we would request a continuance in order for an accurate PSI to reflect for sentencing.
Okay, Mr. Morsinski, have you had a chance to look at that?
Only in that Austin advised me prior to the hearing that error was in there. I told him I would review it. I didn't have any objection to his request for a continuance, so we could get that sorted out. I did also advise him, as you may recollect, Your Honor, this morning we had Mr. Jackson set for a first appearance on a 24 CR 143. He didn't appear this morning, but the state requested that we essentially second call it to Austin's docket so we could do the first appearance there. So I have no objection to the continuance, but I do ask that we go ahead and proceed to first appearance on that new case.
I'm with you on that. I remember the request from this morning, but I do have, or I signed a journal entry of dismissal on that 24 CR 143. I did that on the 15th. I understand it takes a little while to get to you, but that case, I guess, shouldn't have been on the docket this morning because it's been dismissed.
Okay.
If you see or think of something different, let us know and we'll correct that. But Mr. Paulsgraf, how much is that? Another?
I would defer to probation, Judge, on how much time. We do have a drug and alcohol evaluation done, and I know that's typically what holds up the process. It would just be time for this PSI to get done, so I would defer to probation.
Mr. Beveridge?
Well, Judge, it's going to depend on what the issue is. If we need to track down a journal entry, we might need some time. So Austin would need to let me know what the problem is.
It would be, would 6 weeks be sufficient? Or
more than sufficient, yeah.
Okay. I would request early October, late August, Judge. Or I'm not October, September, sorry, Judge.
Huh? So Thursday, September 5th.
That would work with me, Judge.
Morsinski.
Sounds great, sir. Thank you.
All right, Mr. Jackson, your next court appearance, September 5th at 2:30. You're ordered to stay in contact with Mr. Paulsgraf. You're ordered to appear in person or by Zoom as Mr. Paulsgraf directs on September 5th at 2:30. Your bond will continue. Any conditions of your bond will continue. Do you have any questions about what we've done today?
No, sir.
All right. Keep your nose clean. We'll see you again September.
All right, thanks.
Thank you.
Yeah, of course.
All right, Mr. Paulgraph, your next witness, or client, excuse me.
Those days, Judge. I have a Miss Asia Young here, Judge.
All right, got it. 2024 CR 133, State versus Asia Young. Counsel, your appearances.
Larry
Marchinsky on behalf of the state.
Austin Paulsgraf representing Asia Young, who appears in person by and through counsel.
Show for diversion or appear. Mr. Paulgraph, what's the status?
Yes, Judge, a diversion application was submitted. I'm sure I've gotten one back from Mr. Marchinsky. I forgot to send that to my client. I would request extended continuance. I think there won't be any need for a future hearing, but to have it on the docket, I would guess around that same September date we just set for Mr. Jackson.
Mr. Marcinski, September 5th for diversion or appear. If filed, she does not need to appear.
I would agree with all that, Judge. I anticipate we should have it off the docket well before September 5th.
All right, Ms. Young, your next court appearance, September 5th at 2:30. You ordered to stay in contact with Mr. Paulsgraf. You're ordered to appear on that date and time if the diversion has not been filed and Mr. Paulsgraf has not released you from that appearance. Your bond will continue, or any bond will continue. Any conditions of that bond will continue. Do you have any questions?
Thank you.
Thank you for your appearance today.
If you haven't heard from me by tomorrow, you need to give me a call, okay? Because that's on me. All right, and so I've got you down to get a hold of you, but if you haven't heard from me, something comes up, call. Okay, all right, you're free to go. Thank you.
Paulsgraf, next case.
Let's try to clear out the courtroom. All right, I've got. Sorry, dude, it's just a second. Frank Nichols, Judge.
Thank you. 2024 CR 119, State versus Franklin Nichols. Counsel, your appearances.
Larry Marchinsky on behalf of the state, sir.
Austin Paulsgraf representing Franklin Nichols, who appears in person by and through counsel.
I show for status conference. Last filing I have is the appointment of Mr. Paulsgraf. Counsel, what can we do?
Judge, this is a fairly new case. Mr. Marchinsky and I did speak about this one. Initial plea offer has been offered. I would like a chance to run that by my client. I would request August 1st if we can get it.
Mr. Marcinski?
No objection, sir. Thank you.
All right, matter be continued August 1st at 2:30. Mr. Nichols, you're ordered to stay in contact with Mr. Paulsgraf. You're ordered to appear in person as he directs August 1st at 2:30. Any bond you're on will continue. Conditions of your bond will continue. Do you have any questions for today?
No, Your Honor.
I appreciate your appearance.
Give me a call no later than Monday, okay? Okay.
Anybody else in the courtroom, Mr. Paulsgraf?
Yes, Judge, I have a Mr. Oakley Williams.
2024 CR 105, 2024 CR 38, 2024 CR 51, 2024 CR 99, all the state of Kansas versus Oakley Williams. Counsel, your appearances.
Larry Marchinsky on behalf of the state.
Austin Paulsgraf representing Oakley Williams, who appears in person by and through counsel.
All four show for status, I believe. Mr. Paulsgraf, where we at?
Judge, plea offer has been extended by Mr. Marchinsky. I ran my client through the details of the plea offer. There are some things that we will need to get sorted out. Mr. Oakley Williams will need to get sorted out in his personal life prior to any entry of that plea. So I would just request a continuance to in order to allow all these things on the back end to occur. If the court would allow it August 22nd, and I would anticipate a plea on that date.
Mr. Marcinski?
That's fine, sir. No objection. Thank you.
All right, so August 22nd at 2:30 for anticipated plea. Mr. Williams, you're ordered to stay in contact. Mr. Paulsgraf, ordered to appear in person August 22nd at 2:30. Bond you're on for all four cases will continue. Conditions of any of those bonds will continue. Do you have any questions for today? Do as Mr. Paulsgraf requests and be ready to make some progress on August 22nd. I appreciate your appearance today.
Give me a call if anything comes up. Definitely check in by like the end of the month, okay? And then, I mean, I don't know if anything will change by then, but you need to let me know where you're at and figure stuff out, okay? Okay, 2:30, yes, sir. I don't have any- So, okay. Yeah, make sure you get that down in your notes. Give me a call by the 31st, all right?
Anybody else in the courtroom, Mr. Paulsgraf?
Yes, Judge, I have an Anthony Rose in the courtroom.
2024 CR 59, State versus Anthony Rose. Larry Marcinski for the state, Mr. Paulsgraf with his client, South Courtroom. Matter shows for status conference. Mr. Paulsgraf, what can we do?
Judge, it's going to be an entry of a plea today. It will be for a DUI plea that we anticipate will have to be set over for sentencing. And I'm prepared to announce the plea when you are ready.
Go ahead, sir.
Judge, it would be a dismissal of count 1, interference with a law enforcement officer. It'd be a plea of guilty to count 2, DUI. When we get to sentencing, the request would eventually be a 6-month underlying sentence with 12 months of supervised probation, a drug and alcohol evaluation as required by law, and the mandatory minimum $750 fine.
Mr. Marcinski, is that your understanding of the plea agreement?
Yes, Your Honor. Mr. Paulsgraf and I discussed it yesterday and reached that agreement, and I concur with everything he just said.
All right, Mr. Rose, is that your understanding? You're wishing to enter a guilty plea to the DUI in exchange for dismissal of count 1?
Yes, Your Honor.
All right, before I can accept your plea, I'm going to explain certain rights to you. I want to make sure you understand these rights. I'm going to ask you multiple questions. If at any point you do not understand a question, please ask me to repeat it or explain it. And if at any point you want to take a break, talk to Mr. Paulsgraf, all you have to do is let me know. Do you understand that?
Yes, Your Honor.
Mr. Rose, are you currently under the influence of any alcohol or illegal narcotics?
No, Your Honor.
You currently take any medication or supplement that may affect your ability to understand and comprehend what we're doing today?
No, Your Honor.
You understand you have a right to a jury trial in this case?
You understand you have a right to a jury trial?
Yeah, yes, Your Honor.
Okay. And in a jury trial, do you understand that to be found guilty by a jury, in this case, a 6-person jury would have to unanimously agree that you're guilty of this crime?
Yes, Your Honor.
You understand it's the state's obligation to prove your guilt beyond a reasonable doubt and that you're not at that trial to prove anything, including your innocence?
Yes, Your Honor.
You understand you maintain a right not to incriminate yourself and a right not to testify at any trial?
Yes, Your Honor.
You understand that in this trial, the state of Kansas has the obligation to present evidence and witnesses in open court. They'd have to testify in front of you. Do you understand that?
Yes, Your Honor.
You understand that you and Mr. Paulsgraf would have the opportunity to cross-examine the state's witnesses and then ask questions in your defense?
Yes, Your Honor.
You understand you have the right to use the power of subpoena to find and compel the appearance of witnesses to testify in your defense?
Yes, Your Honor.
Do you understand you're not required to plead guilty to any crime today?
Yes.
You understand if you do plead guilty, you basically agree and admit that you've done what the state of Kansas alleges you've done in count 2 DUI?
Yes, Your Honor.
You understand if you plead guilty, we will not have the trial we've been discussing?
Yes, Your Honor.
You understand if you plead guilty, we do not have that trial. You lose any right to appeal trial errors that may have occurred at that trial?
Yes, Your Honor.
You have any questions about these rights?
No, Your Honor.
Is it your desire to give up and waive these constitutional rights to enter a guilty plea today?
Yes, Your Honor.
Sir, to the charge made in count 2 of Sumner County Case 2024 CR 59, alleges a violation of KSA 8-1567A2, DUI, driving while intoxicated, occurring on or about the 12th day of April 2023 in Sumner County, Kansas. How do you wish to plead?
Guilty, Your Honor.
Mr. Marcinski, brief factual basis on the DUI.
Thank you, Your Honor. Should this matter have proceeded to trial, the state believes it could have proven through the testimony of witnesses and presentation of exhibits that on or about April 12th of 2023 at an address here in Sumner County, Kansas, that Deputy Elliot Hess of the Sumner County Sheriff's Office observed a Chevy truck in the 1000 block of East 120th Avenue in the rural Sumner County, Kansas. She made the decision to check on that vehicle and the occupants who were standing outside of the vehicle. As she turned around to make contact, she indicates that the vehicle then began rolling westbound. She followed the pickup for approximately half a mile, during which time she observed weaving and swerving in the roadway, and also an inoperable tag light. Based on those things, Ms. Hess made a traffic stop. Mr. Rose was identified as the driver of that vehicle through his Kansas driver's license. Based on those driving cues, Ms. Hess requested Mr. Rose conduct standard field sobriety tests. Based on those standard field sobriety tests, Ms. Hess believed that she had probable cause to request a PBT. That was declined on behalf of Mr. Rose. Based on the driving cues and the failures of the standard field sobriety test, it was decided to put Mr. Rose into custody. He was taken to the Sumner County Jail, whereat he refused a blood test. At that time, the sheriff's office requested a blood draw warrant, which was signed by the judge. The blood draw was performed, and I only presume that those KBI lab results did come back sometime around February of this year is when we got those blood test results back from KBI. Those indicated that Mr. Rose's blood BAC was 0.11 per 100 milliliters of blood, which would have exceeded the 0.08 legal limit for driving under the influence of alcohol in the state of Kansas. So that would be an overview of the state's evidence should this matter have proceeded to trial.
Thank you. Mr. Rose, do you agree that the state of Kansas has evidence and that they could submit proper and sufficient evidence at a jury trial to convict you of this crime?
Yes, Your Honor.
Are you pleading guilty because you are in fact guilty?
Yes, Your Honor. I know I was in the wrong.
All right. Mr. Rose, court will accept your guilty plea, find you have voluntarily, knowingly, and intelligently waived your constitutional rights to enter your guilty plea today. Court finds factual basis for your guilty plea and further finds that you understand the nature of the charge and the consequences of your guilty plea. As such, court will find Anthony Rose guilty as charged in count 2 of Sumner County Case 2024 CR 59. Plea agreement, the court will dismiss the remaining counts of that complaint. Court will order a drug and alcohol evaluation to be completed by Mr. Rose, that for the anticipated sentencing. Mr. Paulsgraf, when do you think we could accomplish that?
Judge, I think the standard right now is 6 weeks, and I can be corrected if I'm wrong. I'd request the August 29th date.
Mr. Marcinski?
I would defer to Austin. He does these a lot more as far as setting up drug and alcohol evaluations and stuff. So if that's what he thinks it's going to need to get it done, I don't have any objection. That date seems fine to me.
All right. Mr. Beveridge, anything on that timeline?
No, Your Honor, I believe 6 weeks is appropriate.
Thank you. Rose, court will set sentencing in this case for August 29th at 2:30. You're ordered to stay in contact with Mr. Paulsgraf. You're ordered to appear in person August 29th at 2:30. Get your drug and alcohol evaluation done. Any bond you're on will continue. Conditions of your bond will continue. You have any questions about what we've done today?
No, Your Honor.
Okay. Again, keep your nose clean. Get your eval done. We'll see you August 29th.
Yes, Your Honor. Thank you very much.
David, does he need to come down and see you?
Yes, please.
Okay. So when we're done, this is how we get it set up for the eval. You need to go downstairs, very bottom. You said you'll see the vending machines. You'll take a left down that long hallway that looks like a dead end, and you'll ring that doorbell, okay?
I'll be right down there.
Sounds good. If you have any issues, let me know.
I apologize for that. Mr. Paulsgraf, next client in the courtroom.
I believe we've cleared the courtroom out, of my clients, to my knowledge. I would suggest Mr. Rupert while we have his connection good right now.
Okay, 2024 CR 30, State versus Robert Roop. Counsel, Larry Marcinski for the state, Austin Paulsgraf with defendant appearing via Zoom. Shows status conference, Mr. Paulsgraf, what can we do?
Judge, if I might interrupt, as you may recollect, we had Miss Stephanie Rupert on before the court this morning with her respective attorney. I'm going to make the same record I made this morning, and that I'm somewhat disappointed in the fact that it would appear to me that the Ruperts took the very bare minimalist action that they could to comply with what I asked them to do. However, that being said, they did comply with what I asked them to do. And so the state's moving to dismiss this case without prejudice based on them fixing the endangering situation.
Ms. Paulsgraf, any record on that?
No objection and no further record for me, Judge.
All right, court will grant the state's request, this matter to be dismissed. Mr. Marcinski, if you'll file an order of dismissal, excuse me, Mr. Rupert. Case is being dismissed. You are discharged from any further obligations in this case. You have no further court appearances. It'll be removed from the docket. Any bond you're on will be released. Do you have any questions?
No, Your Honor. Thank you.
Appreciate your appearance. Appreciate your patience.
Not a problem. My pleasure. You have a great day.
All right, Mr. Paulsgraf. I've got Mr. Stephen or Stephen, Mr. Boyd, Mr. Frazier, Mr. Miller.
Yes, Judge. Mr. Frazier is on the screen right now. I think we should take his case.
Got it. 2023 CR 300,060, the state versus Zachary Frazier. Marcinski for the state, Austin Paulsgraf in the South courtroom. Mr. Frazier appears via Zoom application. Mr. Paulsgraf, what can we do?
Judge, I believe we're prepared to enter a plea at this time, and I'm ready to announce that the court's ready to hear it.
Go ahead, sir.
Judge, we would be pursuant to plea negotiations, dismissing the criminal damage to property. It would be a plea of guilty to the assault count. The joint request to you today would be for $100 fine. The mirror has been paid for, that was the alleged criminal damage. So at this time that there is no restitution claim. The court costs and attorney fees as the court deems fit. I would make a Robinson motion in this case when we get to that point.
Okay. Marcinski, is that the state's understanding of the plea agreement?
It is, sir, I believe. I was recommending a 5-day underlying jail sentence, but that
yes, okay.
time to pay.
So
I'm not requesting probation.
For a point of clarification and for my client as well, Zach, it's the state's request for a 5-day underlying jail sanction pending your payment. So in short, you just need to get it paid, and the teeth of not getting it paid is the 5-day underlying sentence. And if you don't have the money at the end of the payment period, you just request more time, and the court more than likely will grant you more time.
You're muted, Mr. Frazier. You'll have to, there you go.
Okay.
All right. It's anticipated you're going to enter a guilty plea to count 2 in exchange for dismissal of count 1 and certain sentencing recommendations. Is that what you'd like to do today?
No.
You would not like to plead guilty to assault today?
No.
Okay. Mr. Paulsgrove.
Judge, I would start by requesting a motion to withdraw for breakdown in communication. This case has been going on forever. It seems like we've been spinning our wheels here. We've changed our mind on what we're doing several times. And if I can't even take a case to plea without knowing the direction of the case, I think my client would be better served by different representation.
Okay. Mr. Frazier, do you disagree with that?
No.
Okay. You would like other counsel appointed?
Yes.
All right, Mr. Paulsgraf, your request to withdraw from the case is granted. If you'll file an order to that effect, I would appreciate it. Mr. Frazier, have you worked with any other counsel in Wellington or Sumner County before?
Not in Sumner County now.
Okay. Mr. Marcinski, do you see any potential conflicts or know of any based on your knowledge of the events?
1 second, Judge. Let me just look, make sure who we're talking about here. Sumner County Sheriff's Office, no, I don't think any of our appointed counsel at this point have any conflicts with the Sheriff's Department, so anybody would be fine, sir.
Does Bach need some cases? All right, Mr. Frazier, court will appoint Mr. Bach Hang to represent you. He's taken cases in Sumner County, been a criminal defense attorney for a long time. He's located in Wichita, but as I said, he's down here weekly now. So I need you, we will get you his information. We have cards for him.
No, we don't, but I can email it to Mr. Frazier if he gives me his email address.
All right, Mr. Well, Austin will know it, so I won't have to put that on him.
Okay.
All right, Mr. Frazier, Mr. Hang will be notified of his appointment. That'll come by order of the court. We need to give him some contact information. Do you want him to contact you by telephone? You have one working?
Yes.
Okay. What's that number, sir?
316-661-5442.
Okay. We will include that as part of his appointment. Which we don't have his business cards yet, but I'm going to set this out. See, you got cases next week, Mr. Hang. We're going to put you on a docket where I know he's appearing. So if you haven't made contact in the interim, that will be the contact. So.
Okay. Thank you.
Yes.
Next week. All right. Next court appearance for Mr. Frazier will be next week, 7 days, July 25th at 11 a.m. Appear in person or by Zoom. That is Mr. Hang's designated time for the docket. He has some other cases, so if he has not seen his appointment and or given you a call at that number you just gave us, we'll make sure you're in contact, and I'll put a note in here showing that you might need a little more time to get to know each other. Okay?
Okay. Thank you, sir.
Bond will continue. Any conditions of your bond will continue. You're ordered to appear July 25th at 11 a.m. in person or by Zoom. I appreciate your appearance today. Appreciate your patience. We will see you in 7 days.
Thank you, Your Honor.
Mr. Paulsgraf, your next case you want to take up?
Judge, it's whatever we're showing on the list for you. You can fire at will because I don't see any of my clients here or on the Zoom.
All right, sir, in the jail, is that not yours, Austin?
Yeah, I guess that would be true. I do have clients at the jail.
Your name, sir, in the jail?
Mr. Boyd.
Boyd, John Boyd?
Yes, sir.
Gotcha. 2022 CR 302, State of Kansas versus John Boyd. Larry Marcinski for the state. Mr. Boyd appears in custody via Zoom application with attorney Austin Paulsgraf. Again, status conference. Mr. Paulsgraf, what can we do? Last week, order appointing you. That was just this week, so it's new to you.
Yeah, Judge, at this point, I'm seeing a battery in my brief look over the facts before I got here. I'm showing a battery from 2022. Since we have a case that's been going on that long and a summons was out, I'd presume my client did not get notice of said summons, or if he did, there might have been an issue with the mail. Bottom line is he's been good for at least 2 years. I would just request an OR bond on this misdemeanor battery.
And I appreciate that. For the record, complaint was filed November of 22. Warrant was issued stemming from the complaint. It just took from November 29th till its return July 15th to serve the warrant. In essence, find Mr. Boyd or run across Mr. Boyd and serve the warrant. So nothing about a summons in that process. That's warrant return. Looks like it was served July 12th, or at least booked into Sumner County. Not sure where it was served or where he came from, if it was another jurisdiction. But request to modify to Mr. Marcinski, state's position.
Judge, this case alleges a jail battery when Mr. Boyd was previously a resident of the jail, got in a fight with another individual named Todd Angevine. Obviously, the anticipated outcome here would probably be probation or a short jail sanction. I typically request short jail sanctions on jail fights. The state's concern would obviously be that I issued a warrant basically when these things happen, and I'm notified that the inmates are in the custody of the jail. Typically for a simple battery, like Austin said, I would do a summons, but when I'm advised that they're in the jail, I just issue a warrant. Obviously, Mr. Boyd was able to bond out of the jail prior to me being able to get my complaint filed and warrant filed. So the state's obvious biggest concern is that his whereabouts were unknown for the better part of 2 years. And so the state would I don't have a major objection to a bond modification because I think ultimately it would be appropriate.
I have something to say, if you don't mind.
Well, I kind of do, but if the judge will allow, I suppose.
Well, Mr. Boyd, you may want Mr. Marcinski to finish what he was saying or the road he was driving down before you. I'm going to let you speak before we're done today, but you want to be patient?
Yes, sir.
Okay, Mr. Marcinski, finish your position, please.
So honestly, Judge, I don't have a major objection to a bond modification here based on the allegations and the presumed outcome should it happen. But due to the exceptionally long period of time that this warrant was outstanding, I think that a professional surety should probably be involved. So I would probably object to an OR bond. I probably would not object to $1,000 cash or professional surety, which would allow Mr. Boyd to be released from custody with a small financial incentive from himself. But that's where I'd be at on a bond modification. I don't seriously or strenuously object, but I do think that due to the long nature that this warrant was outstanding, that a bondsman should probably be involved in the release.
All right. Mr. Paulsgraf, if Mr. Boyd wants to address us, is that okay with you?
I would strongly advise that he doesn't unless he has something of merit that's going to help his position. And since I haven't had the opportunity to speak with him, sounds like he was just given a gift if the court were to accept what Mr. Marcinski just said. So at this time, I'd advise my client to remain silent.
Mr. Boyd, there's probably a difference on what Mr. Paulsgraf saying. If you're talking about perhaps why a bond modification would be appropriate.
I'll remain silent.
Okay. All right. Where do you live, Mr. Boyd?
I live in Wichita. I'm supposed to be going to a halfway house. Like I done my time. I went to prison.
for like 2.5 years, got out. That's when they got me and brought me here. I had to serve a 3.5 year prison sentence. I'm currently on parole. I have to report to a parole officer in Wichita as soon as I get done with here. Okay, and I'm on disability. I have no family. I don't know anybody in this county. Okay, I just got in trouble here is all I'm saying. Wichita farmed me out. I got in an altercation with another guy here.
Okay.
That's all it was.
Mr. Marcinski, could I ask, do you know if your alleged victim is local? I mean,
Mr. Angevine was a Sumner County local inmate. Yes, Mr. Angevine is local to Sumner County. Judge, I'm reviewing Casper, and Mr. Boyd is being candorous with the court. According to Casper, he was released or paroled to our detainer on July the 12th. And so he has been in KDOC custody for that entire period of time, which does, again, obviously give some excuse or reason why he failed to appear. The warrant's been outstanding for that period of time. So I still have the same concern, but if the court thinks that an OR bond is appropriate, I would perhaps ask for a slightly higher OR bond, maybe $2,500 to give him a financial impetus to appear in court. But I'm reviewing Casper, and I believe that his statements to the court are truthful. It does appear he just got out of KDOC, where he's been since, well, he can probably tell us, but it looks like sometime RDU in January of 2023. So he has been there for about 1.5 years in KDOC custody.
Yeah. Okay. Mr. Boyd, I'm inclined to modify your bond to an OR bond, but I need some sort of assurances that you'll stay in contact with Mr. Fallsgraf. I'm not trying to disrupt any treatment plans. You're being on paper on post release or parole, but we need to know where you're at between now and your next court appearance and so on. Candidly, I think if you were in KDOC and they didn't serve the warrant until they were done with their purposes, I'm not sure I find that to be very just for your purposes. You should have been able to have the opportunity to address this while you were in KDOC. So that's where I'm coming from on the rationale for modifying your bond to $2,500 OR. You need to make sure all your contact information is to Mr. Fallsgraf before you leave Sumner County, I suppose.
I will. My parole officer at KDOC 212 North Market is my parole officer's name is Ryan. I have all my information in my property, and I have to report to him as soon as possible anyway. So as soon as I'm done here, I got to report to him in person, and he knows about this battery as well. So I don't violate my parole or anything like that right now.
Yeah, Mr. Boyd, we appreciate you going up there. All the judge is telling you is when you get out, you need to make contact with me, okay?
I promise.
And so you have some security. This event happened before you were put on parole, so this couldn't possibly violate your parole. And if he needs to hear that from me, I'm happy to talk to him about it. But do what you're supposed to do, being on paper with KDOC, stay in contact with Mr. Fallsgraf, and we'll see you at your next court appearance, which will be Mr. Fallsgraf. Your thoughts?
Judge, I would request a 3-week continuance. Approximately the 22nd or the 15th, whatever this court deems reasonable.
Let's see, we got about August 8th. That's the light or docket we're somewhat keeping light. Not sure who's covering that one. Mr. Marcinski?
August 8th should be just fine, sir. I don't see any conflict with that. That'd be great.
I agree, Judge. Thank you.
Mr. Boyd, your next court appearance will be August 8th at 2:30. You need to appear in person or by Zoom, how Mr. Fallsgraf directs. Worst thing you can do is not appear and not have any contact with Mr. Fallsgraf. Your bond's modified to $2,500 OR, meaning you sign out with your own signature. We will get any appropriate paperwork to the jail. I'm putting notes in right now. Do you have any questions about what we've done today?
No, sir.
Judge, I guess I would interject one last thing. I don't know if it's appropriate or not. I just want to make clear for the record that in regards to this exact same jail fight, I believe Mr. Angevine was sentenced to 7 days in custody as a sanction for getting in a fight at the jail. I always pride myself in equity and trying to do for one defendant what I would do for the other. So he needs to discuss it with Austin and decide what he wants to do. But if he wanted to stay in custody for a couple more days, he could probably walk down this case and be done with it. So I will leave that discussion to Mr. Paulsgraf and his client, but most likely the state's going to recommend a 7-day sentence in regards to this fight, the same I gave to Mr. Angevine. So keep that in mind. If he doesn't want to bond and just do a few more days, he might be able to just walk the case down.
Judge, given that the remainder of my clients looks like a healthy amount of failures to appear, could we do a brief breakout room since I have the courtroom to myself? It should take no more than 2 minutes.
Certainly can. Mr. Boyd, I'll give you a breakout room for just you and Mr. Graff. If you heard Mr. Marcinski, we could put you on the docket for next week, perhaps handle it, and you could be done fully discharged from this case. It sounds like that would be the plea offer from the state. I'll give you an opportunity to talk to Mr. Paulsgraf right now, okay?
Yes, sir. Yeah, I'll take that.
No, he's setting it up.
Hold on just a second. South courtroom and the jail. Open rooms. All right, Ms. Paulsgraf, if you know how to handle that, jail, I know knows how. We'll get you with Mr. Boyd in a breakout room. Marcinski, I'm not going anywhere, but I'm gonna take my camera down and mute until they come back.
No worries, sir. I'll be right here.
All right, Mr. Paulsgraf, how would Mr. Boyd like to proceed for today?
Judge, I believe, and thank you for giving us that opportunity. I believe he's prepared to enter a plea today. After hearing what Mr. Marchinsky said, I would presume the sentencing recommendation is for 7 days and close the case with any fines and fees he deems reasonable.
Mr. Marcinski, is that, I mean, if he pleads as charged to that count of battery, the state's recommending 7 days credit for time served, so he's got a day or two, maybe 3 days left, and then he's done. You're muted, Larry.
Sorry, I was muted. To be clear, Judge, yes, the state would recommend a 7-day underlying jail sentence. I would not request a fine. Any other court costs or appropriate fees, I would leave to the sound discretion of the court. I would note in reviewing Mr. Boyd's court case, it does appear to me in reviewing his inmate booking sheet that he was booked into the Sumner County Jail on July the 12th. So he would have served 6 days as of today. So if the court was inclined to follow the sentencing recommendation of the parties, I believe Mr. Boyd would be released from custody probably sometime tomorrow. The booking sheet indicates he was arrested at July 12th at 14:12. So I think that would be then he would be released tomorrow at approximately, 3:15 in the afternoon, give or take.
Okay. Mr. Boyd, is that how you'd like to proceed today, sir?
Yes, sir.
Okay. Go through some rights, probably go pretty quick. Sole count of the complaint, battery. Do you understand where all this is coming from?
Sir.
All right. Are you all under the influence of any alcohol or illegal narcotics?
No, sir.
Having any difficulty understanding or comprehending what we're doing today?
No.
You understand you have a right to a jury trial in this case?
Yes, sir.
You understand that you'd have representation at that trial if we had a jury trial?
Yes.
You understand you have the right to use the power of subpoenas for witnesses in your defense?
Yes.
You understand if you plead guilty today, we will not have that trial?
Yes.
Is it your desire to waive your constitutional rights to a jury trial in order to enter a guilty plea today?
Yes, sir.
To the charge made in Sumner County Case 2022 CR 302, to the sole count alleging a violation of KSA 215413A2 battery occurring on about the 9th day of November 2022 in Sumner County, Kansas. Mr. Boyd, how do you wish to plead?
I plead guilty to it, sir.
Okay. Mr. Marcinski, based on your recollection, Mr. Boyd's thoughts, some from Mr. Paulsgraf, I think factual basis exists. Court could take judicial notice of the victim's case as well, I guess of Angevine, excuse me. So I can find a sufficient factual basis unless you have something else, Mr. Marcinski.
Judge, I think just in support, so the court understands why I'm only recommending 7 days here. According to the affidavits and the reports that I have, it indicates that Mr. Boyd punched Mr. Angevine in the face 2 times. And that it was resulting of them two getting into some sort of a scrap in their pod. So in reviewing the reports, it's a fairly minor battery as far as they go. So I try to recommend my punishments based on the severity of the case here, and I think that 7 days is more than sufficient based on what I'm seeing here. So I would ask the court to consider doing that. Again, I'm not requesting a fine, and I would stay silent on any additional or applicable costs or fees and leave that to the discretion of the court.
All right. Mr. Boyd, do you agree that the state of Kansas possesses or can find evidence sufficient to prove you guilty at a jury trial?
Yes.
And are you pleading guilty today because you are in fact guilty?
Yes, sir.
We'll accept your guilty plea, find you have voluntarily, knowingly, and intelligently waived your constitutional rights to enter that guilty plea. Court finds factual basis for your guilty plea, further finds you understand the nature of the charges and the consequences of your guilty plea. Find John Boyd guilty as alleged in count 1 of 2022 CR 302. Mr. Paulsgraf, any further recommendations for sentencing?
Just that the court follow the agreed upon plea, Judge.
Mr. Boyd, you have the right to allocution. You have the right to make a statement or present any evidence in mitigation of punishment. You're also not required to say anything, and I'll candidly tell you, I'm going to follow the recommendations.
Sir.
You wish to make a statement?
No, sir, I do not.
All right, court, be the order and judgment of this court, John Boyd be sentenced to serve 7 days in the Sumner County Jail, him to be given credit for time served, anticipated release on July 19th, sometime after, I think, 2:15 PM. Court waives reimbursement of court costs and his court-appointed attorney's fees, waives any imposition of booking fees. So he serves his time and gets on to the road back on his parole in Sedgwick County. Mr. Marcinski, anything else from the state for today?
No, Your Honor. Thank you.
Mr. Paulsgraf?
No, Judge.
Mr. Boyd, straight up 7 days, no financial obligations. Do you have any questions?
No, sir.
Mr. Boyd, I wish you luck on your paper.
Thank you.
Clean. Good man. Yes. All right, let's see, Mr. Paulsgraf got 4 more. We'll go down the docket, 2022 CR 158, State versus Matthew Stephen or Stefan.
Yes, Judge. He appears at the jail.
All right, appears via Zoom application in custody. Mr. Marcinski for the state, Mr. Paulsgraf with the defendant. Shows status, Mr. Paulsgraf, what can we do?
Yes, Judge. This is a probation violation second. I believe it's my client's intent at this time to stipulate.
All right. Is there an agreement for disposition?
Judge, after speaking with probation, I know their recommendation, it would be, and Larry, you can please correct me if I'm wrong in my understanding on what, if you would join in on that, but I know that probation would be recommending 30 days, extend probation for the 12-month or the underlying probation period. I believe it's 12 months in this case. For a drug and alcohol evaluation to be done and to follow any recommendations of said evaluation, if that includes inpatient treatment.
Mr. Marcinski?
Yes, Your Honor, I think that is very appropriate. I would follow or join in with that recommendation. I think the only thing I would add to it, based on the rather lengthy affidavit here alleging violation or alleging positive usage of THC and alcohol, I'm looking at his underlying journal entry of conviction, and it doesn't appear at that time that the state requested a drug and alcohol evaluation. So I would recommend upon stipulation for the jail sanction that probation is requesting, and I would ask that the court impose a new additional condition ordering Mr. Stephen to get a drug and alcohol evaluation and to follow any recs of that. But and I would also concur that he should get credit for any time he's been sitting waiting on this hearing. And it was appear to me that he has been in custody since July the 12th, sir.
All right, Mr. Stephen, is that how you'd like to proceed? Do you anticipate admitting to violations of your probation today?
Yes, Your Honor.
All right. We'll go through a couple rights. Mr. Stephen, do you understand you have a right to contest the allegations of the motion to revoke and the supporting affidavit, and we could do that at trial?
Yes, Your Honor.
It's the state's burden to establish a violation of your probation by a preponderance of the evidence. Do you understand that?
Yes, Your Honor.
I understand you have a right to have an attorney. In this case, Mr. Paulsgraf represents you at that hearing.
Yes, Your Honor.
You understand you have a right to present testimony to witnesses and other evidence in your defense of the allegations. You understand if a violation of your probation is established, either because you admit today or because the state proves that at a trial, this court then has the authority to continue, extend, or revoke your probation and could require you to serve the underlying sentence of incarceration.
Yes, Your Honor.
Have any questions about those rights?
No, sir.
You fully understand which conditions of probation the state says you violated?
Yes, Your Honor.
You wish to waive all the rights to the probation violation process and enter admission today?
Yes, sir.
The allegations set forth in the motion to revoke probation supporting affidavit filed May 31st. Mr. Stephen, do you admit or deny that you have failed to refrain from the use of alcohol and drugs, and that's a violation of your probation?
I admit, sir.
Sir, do you admit or deny that you were admitted to drug court? You admitted to a drug court that you used THC on or about March 28th of this year?
Yes, Your Honor.
You admit or deny that you admitted to using THC on or about May 12th of this year?
Admit.
You admit or deny that you had UA results positive for alcohol on May 7th, May 9th, May 13th, May 16th of this year?
I admit, sir.
You admit or deny that you've had UA results on May 21st positive for both alcohol and THC?
Yes, sir.
You admit or deny that you last used alcohol on or about May 28th of this year?
I admit, sir.
Sir, the court will find you have knowingly, willingly, and voluntarily waived your rights to the probation violation process. Court finds you understand the potential consequences of waiving those rights and enter an admission today. Court will accept your admission stipulation, find you have violated probation as alleged in the motion to revoke and the supporting affidavit. Mr. Marcinski, any further recommendations from the state?
No, Your Honor. Thank you.
Mr. Paulsgraf?
Just to add, on top of why it's our belief that the court should follow the recommendation, to our knowledge, my client did turn himself in upon finding out that there was a warrant. I believe he went to go meet with Mr. Hollis, or I went straight to the jail, one or the other, and that he was in a sober living house. After the violations, but before today, he's been in a sober living house.
Okay. Mr. Hollis, anything to add?
No, Your Honor.
Very good. Mr. Stephen, you have anything to say in mitigation of disposition? You're not required to say anything to this, your opportunity if you wish.
No, Your Honor, all I would like to say is that I do admit to using, but as soon as I'm pretty sure it was at the end of May, I got into a sobriety house and I've been in sober living since, and that's where I'm going as soon as I get back out of here. So.
Okay, very good. Court will enter disposition as follows. Follow recommendations as I understand them. Mr. Stephen will be ordered to serve a 30-day jail sanction, credit for time served, extend his probation for a period of 12 months on all original terms and conditions, plus add a special condition of a new drug and alcohol evaluation, and him to follow and successfully complete all recommendations. If that's his halfway house and that's sufficient to Mr. Hollis or court services, I understand, and they can substitute that for the new drug and alcohol eval and recommendations. But that's going to be with court services. Court will waive reimbursement of court-appointed attorney's fees for the probation violation process. Sir, upon your release, you're to immediately report to court services in the basement of the Sumner County Courthouse, or the next day if you can't make it here by 5. Do you understand that?
Yes, sir.
Mr. Hollis, anything else from court services?
No, Your Honor.
Anything else from counsel?
Not on behalf of the state, sir. Thank you.
Not at this time, Judge. Thank you.
All right, Mr. Stephen, good luck to you, sir.
Thank you. You too, Your Honor.
Huh. 24 CR 66, State versus Corey Miller.
Yes.
State.
Austin Paulsgraf representing Corey Miller. Judge, at this time, my client does not appear, but I would strongly argue, maybe Larry would even provide, I think there was probably a miscommunication between my client and myself on this one. So if we don't do a dismissal today, Mr. Marcinski, I would just argue for a continuance to get him here, because I will be able to get him here.
Judge, this is somewhat similar to the Ruperts that we've dealt with today, and that the state felt that there needed to be an intervention here, but Mr. Miller has done what the state has asked him to do in regards to this. This is a contributing to a child's misconduct for truancy. Mr. Miller has since gotten his child into therapy with Sumner County Mental Health. So Austin and I have reviewed this case quite frequently. We discussed it yesterday afternoon. At this time, it is the state's intent to dismiss this case without prejudice. Like we've discussed, and Mr. Miller isn't here to hear me say it, but should these truancy issues continue on in the next school year, I might readdress it at this time or at that time. But based on Mr. Miller getting his son into therapy and trying to work through this situation as reasonably as he can, at this time the state is going to go ahead and move to dismiss without prejudice. No need to push it out. That was the plan, so.
Ms. Paulsgraf, any objection or record?
No objection at this time, Judge. No record.
I'll grant the state's request for dismissal, ask the state to file an order.
Yes, sir.
Matter to be removed from the docket.
Yes, sir.
23 CR 300,044, 2024 CR 75, both the state of Kansas versus Derek Hibbs. Mr. Marcinski for the state, Mr. Paulsgraf in the South courtroom. No Mr. Hibbs. Mr. Paulsgraf, go ahead.
Judge, I'm a little perplexed on this one. My client completed inpatient treatment pursuant to court order via the last order from this court. And because of that, we were hoping for a good resolution, but he is not here today. He should have known that we had court today. At this time, I'm sure the state would have a motion, but I would just request for a 2-week continuance.
Marcinski.
It's just somewhat unusual. I was actually going to request a continuance myself. Austin and I have discussed this case at length, and I'll be forthright that it's ultimately kind of anticipated that I'm probably going to dismiss these two matters. Mr. Hibbs has been working on himself, getting himself through treatment. I was going to make the announcement today that I did fail to. I've been working deeply with his family in regards to this case of trying to find an outcome that would be best for the community and best for Mr. Hibbs and best for his family. And so the reason I was going to request a continuance today is that I had not had an opportunity to reach out to his mother and his family to advise him of my intent to dismiss. So I was going to request a continuance to make victim notifications because technically his mother is listed as the victim in the domestic battery case. So I hadn't notified her of my intent to dismiss yet. I've had multiple conversations with her and I don't think it's going to be any surprise. But so based on my intent to request a continuance so I could speak with Ms. Leverage, I don't object to Austin's request for a continuance. I would say that if Derek doesn't show up in a couple of weeks when it gets reset, I probably will ask for a warrant at that time. Because I'm concerned. He does great and then he falls off, and he does great and then he falls off. So where we're at right now, I was under the impression he was doing great. So no objection to the request for 2 weeks with that brief record, and I will reach out to Miss Leverage before that. So should he show up at that time, the state will be ready to dismiss or take further action.
Thank you. Ms. Paulsgraf, August 1st at 2:30.
Works with me, Judge. Thank you.
All right, matter continue that date and time. Show the defendant needs to appear in person or possible bench warrant to issue. All right, finally, for Mr. Paulsgraf, 2024 CR 162, State versus Edward Horn. Mr. Marcinski for the state, Mr. Paulsgraf in the South courtroom. Mr. Paulsgraf, where are we at?
Judge, I have not spoken with my client. My client is not here. He has not reached out to me at this time. I'd request a continuance, but once again, I'm sure the state has a motion.
Mr. Marcinski.
Judge, on this one, I am actually going to go ahead and probably move for the court to issue a warrant. Unlike the last case we just discussed, Mr. Hibbs has been in contact with Austin frequently. It is my understanding, and I don't want to misspeak, but Austin and I discussed this case, and it was my understanding that Mr. Horn has not reached out to him or made contact. And so for that reason, Austin does an amazing job of trying to reach his clients. And so with the idea that Austin has done that and Mr. Horn has not reached back out to him at this time, just to try to get the case moved ahead, the state is going to request a bench warrant. I do recollect that this is just a criminal damage to property case. It's alleged that he broke out a window of a police cruiser. I don't recollect if he's on summons or a bond right now. I'm trying to look that up real quick.
It's like 5,000 cash commercial. It's a commercial surety bond of 5,000 that was posted June 26th.
That leads to even additional concerns, Your Honor. If he's posted a professional surety bond and still isn't coming to court, that obviously has additional concerns to the state of Kansas. So based on the record that's been made here, the state would ask that that bond be forfeited and that the court consider either 7,500 or 10,000. To be honest, it's typically my modus operandi to ask the court to double the bond in this situation. But again, this is a Class B misdemeanor for damage. So I would defer to the court of what you think is an appropriate bond amount.
Thank you. Court shows defendants failed to appear as previously directed or ordered by the court. Any and all bonds revoked in this case. Bench warrant to issue with bond set in the amount of 10,000 cash or commercial surety. And notify counsel if and when Mr. Horn is located in Sumner County. Mr. Paulgraff, that's all the cases I showed for you. Anything else?
Not at this time, Judge. Thank you.
Appreciate your work.
You have continuance in your queue for Mr. McCartney, continuing to 8/22 at 3:30, as
Okay.
soon as you sign it.
Mr. Gehring, are you here on the McCartney case?
Yes, Your Honor.
Okay, I just informed we've got proposed order of continuance that I've yet to look at or sign. You need a record of anything for today other than that?
No, Your Honor. I think from talking with Matt, I think it's just waiting on a check to get to Larry's office, and once it gets there, we should be done, so.
Okay, I will sign the order that's been proposed and sitting in the queue. You know what date that goes to off top of your head?
I do, Judge. It was August 22nd at 3:30 in the afternoon. And I had no objection. I advised the Mr. Levitt that I didn't have any objection.
Happy to get that signed. Mr. Gehring, thank you for your appearance. Thanks for your patience waiting on that.
Thank you. Have a good day, guys.
See ya.
Take care.
Larry, any other cases today?
No, sir. It was a long docket today, quite a marathon. Appreciate your time.
Yep, that good work. You got a lot off your plate.
Yep.
All right, that concludes the criminal docket for Sumner County.